the findings. So let me turn to counsel on that one. What's your position?
Yes, Judge, we reviewed the report and the findings of the Center for Forensic Psychiatry. We would stipulate to a finding of competency based upon those results.
Fair enough. So what I'll do is I'll enter an order to that effect. We have I think we have a scale or a form order to that effect. And the order that we will enter will say that the case will simply then go back into the normal process. Presumably that means that we would at some point schedule a status conference to see if the case could be resolved. And of course, there's always a possibility that a defendant would like to exercise his right to trial. So thank you very much. Have a nice weekend.
Thank you, Judge. You too.
I see everyone.
Folks, do you have stuff before the court this morning? Do you have things before the court this morning, or are you just watching?
He's Mr. Perez.
Oh, you're Mr. Perez. Got it. Thank you. I mean, it's a public courtroom, so everybody can come in and watch. I just wanted to make sure we were going to take care of you if you had something before the court. Thanks.
Okay, is that better?
There you go. That is better.
Your Honor, the next case is the People versus Julian Robertson. This is case 2205541FH. Please state your appearances for the record.
Kim Richards, People.
Michael Anderson on behalf of Mr. Robertson.
Good morning to you, Mr. Anderson. The defense in this case, that is Julian Robertson, through Mr. Anderson, his counsel, has filed a motion for an evidentiary hearing. I've had a chance to have a nice weekend, folks. I've had a chance to review this. I also actually spent a little bit of time yesterday afternoon doing some research. But let me see if I can summarize this. I mean, as I understand it, this is a case in which the police ended up following a vehicle and they believed that the person who was driving the vehicle was one guy, but it turned out that it actually wasn't that guy. And there was some basis for the confusion because I think the defendant in the case was, like maybe in front of a residence, and then the person who actually lived in the residence might have had some criminal history, et cetera, et cetera. But I'm just giving a fast overview, and of course I'll turn it over to counsel. So Mr. Anderson's argument is that while he concedes that there is a law, including U.S. Supreme Court law, that says that it can be okay if the mistake of identity is reasonable. And Mr. Anderson says, I think the court should hold an evidentiary hearing to determine whether, in fact, the mistake in this case was reasonable. I get a response from the people who say, what do we need an evidentiary hearing for? Because the fact of the matter is that the real question isn't whether or not they made a mistake. The real question is whether or not they had reasonable suspicion to pull over a motor vehicle after they had seen the person who was driving the motor vehicle to be armed with a gun in his waistband. And so their position is it doesn't matter, because the bottom line is my officers, if you will, or our officers had every right to pull the vehicle over after having seen somebody with a pistol in waistband, et cetera, et cetera. And then they pull him over, and then, the rest is history. And Mr. Robertson is ultimately arrested and charged with, I believe the charge in this case, Mr. Anderson, is in fact a gun offense. Is that correct?
That's correct, Your Honor.
Okay. So Mr. Anderson, that's just kind of my summary. Let me turn it over to you.
Thank you, Your Honor. Yes, I mean, the question is whether or not the stop is reasonable. And the first issue I have primarily is the footnote that the preliminary examination was waived. I would note in this case, as a matter of course, but typically when there's evidentiary issues, we'll be told, ask for an evidentiary hearing in circuit court and preserve the offer by waiving the preliminary examination, which is exactly kind of what triggered Mr. Robertson to waive in this case in the first place.
I mean, I have to tell you, Mr. Anderson, I mean, I barely even noted that. I mean, it's obviously, your call as the defense and the defense lawyer as to whether you want to waive a prelim. I'm not holding that against anybody. I mean, I get it. You decided you didn't want to run the prelim. Now you're arguing that now that it's in circuit court, we do want an evidentiary hearing so that we can develop the record. I totally get that part of it.
Okay. Then with regard to whether or not it's reasonable, first of all, we would not stipulate that what's contained in the police report is accurate, but even using that, they note that it was a person with a previous concealed weapon arrest, not conviction. Defense counsel looked up, the case of this person that they confused it with, and that arrest was in 2014. So there's no indication that they made any effort to, because if a person has a CPL, they're legally allowed to carry a weapon in the car.
But here's my question, Mr. Anderson. I mean, let's presume, and I'm happy to presume. I mean, I would always give you the benefit of the doubt that everything that you're saying is true. But what difference does it make whether or not it turned out to be the resident who had the priors, if in fact the police saw somebody with a pistol in their waistband and then driving? I mean, I went through this yesterday. The observer.
I'm sorry, Your Honor.
Well, look. So here's what I've got here. They see a guy reaching into a vehicle, which apparently turns out to be the defendant. The police see a gun tucked into his waistband outside of a residence. Later, we find out that the person who's living at the residence, a guy named Dante Richardson, the police find this out, had a previous CCW arrest, and he also resembled the man seen with the gun. I don't think any of that is at issue. Then they observe the defendant, that is the guy who had the gun in his waistband, get into the vehicle with the gun. They then flash their emergency lights, which he did not originally stop at. And then they put on their air horn. He finally stops the vehicle, and then they find a gun under the driver's seat. So I just want to make sure I understand what your argument is, that they never had a basis to even pull the car over. And is it your position that even though people can in fact get CPL licenses, that when the police, who likely would not know, especially if they're considering pulling somebody over, whether that person has a CPL, they know that this is a person who has a gun in a motor vehicle, which is presumptively illegal unless that person has a CPL. Am I not right about that?
Well, there's a few things in there. One is this person was at their residence that got into the vehicle. They were not at the scene. They actually left and came back because they had answered another call. They have no idea whether the gun was properly stored in the vehicle. They didn't observe him for that period of time. I think I can present evidence from the video of the stop that, in fact, they followed him for a period of time. He did not commit a traffic infraction, and he pulled over almost immediately when the lights were put on.
Well, I get that, but what I'm focusing on is, I gather it's not in dispute that the police saw the defendant with the gun in his waistband. They then see the defendant get into a car and drive away. And I'm saying, isn't the fact that somebody with a gun in his waistband who gets into a vehicle, that's not enough to stop a vehicle? because presumptively, it's a crime, to essentially carry a firearm in a vehicle, right? And it's only not a crime if he has a CPL.
No, it would be presumptively not a crime, Your Honor, because they have to have reasonable suspicion. They can't just stop everybody they see with a gun get into a car.
Don't they have reasonable suspicion that he's committing a criminal offense when
No.
he takes a gun into a vehicle?
No, because he got into the vehicle on his own property. He's allowed to conceal it. And they have no idea whether or not the gun was properly stored. The vehicle he was pulled
He
over
may
in
have been
doesn't have a
allowed to
trunk.
conceal it on his own property, but it's a crime to have a gun in an automobile, isn't it? Unless you have a CPL. And how
No,
are they
it's not.
supposed to know?
It's
It's
not
not.
required. No, because the vehicle doesn't have a trunk. So they have no way of knowing whether the gun is legally stored in the vehicle. And that notwithstanding, they still have to, they can't just pull everybody over that they think is committing a crime. It's not reasonable suspicion because they are legally allowed to carry. They have to see some evidence of criminality, and they didn't.
You acknowledge that first of all, let's be clear about our standards. You acknowledge that the pulling over of a vehicle is not a probable cause standard, it's a reasonable suspicion standard.
That's correct.
Okay.
But there's more of an inquiry there because at that point, even they have plenty of time during the traffic stop to even identify the person or even ask him a question. But they take him, they detain him, they arrest him in the back of the car and go forward as if it's this other person when it's not.
Fair enough. Ms. Richardson.
Your Honor, I think our brief was clear. I think that the traffic stop was reasonable. So I guess I'd recommend our brief.
Well, let me ask you this, because Mr. Anderson is making an argument of the law, which I'm the first to admit I may not understand or know. He's essentially saying that even under these circumstances, they had no basis to stop the vehicle because it's not illegal for somebody to have a firearm. And it's certainly not illegal for somebody to have a firearm in their home. And then you heard my questioning, which was, well, yeah, but once he gets into a car, and Mr. Anderson is saying, and he may or may not be correct about this, that even though they see somebody with a gun in the waistband getting into a car, that in and of itself is not reasonable suspicion to stop the vehicle.
Well, I don't believe that's the only reason they stopped it, Your Honor. They also had a suspended license and they were investigating. So I don't think it was the only reason.
Well, Mr. Robertson did not have a suspended license. But I think that the inquiry is whether or not it's reasonable. I don't see that there's any harm in questioning the police officers to determine the reasonableness of their determination and why they pulled him over.
I guess I don't understand what the evidentiary hearing would be. We all know what the facts are here.
Well, no, because they know in the police report that the reason they stop him has nothing to do with him getting in the car with the gun. It's because they thought he was a felon in possession of a firearm. That they made no effort or inquiry to make sure that first of all, that person who they thought it was had legally obtained the right to have a firearm, because the arrest they refer to is from 2014 and this is 2022. They also make a note of 5'11", 180 pounds, but the report that this arrest came from says 6'2" and 225 pounds. So they just pull over a guy that's black and has dreads. When there's no way, because you can carry a firearm in a car, it's perfectly legal to do so as long as it's properly transported. Whether or not they could make a determination as to whether or not the gun had been properly stored in the vehicle, they just didn't do that. So this is a rendezvous. It has no trunk. It's just like a truck. You just have to put the gun as far back in the car as you can, right? So that it's not accessible to the driver. They have no way of saying that it did. So they need some other reason to make this stop. And if you watch the video of the stop, he makes no traffic infractions. He pulls over on the wealthy ramp as soon as they light it. They're following the whole time, having a conversation, trying to find a reason to pull him over. When he doesn't, they say, well, we don't want to get him on the highway. And so that's why they stop him on the ramp. And then there's further, once they have him in custody, they make no effort to identify who he is or even have a conversation with him. my point would be that if they thought he was a felon in possession, there was no reason to wait for him to get into a car and drive away and do a traffic stop. They could have done a citizen contact right at that point. So they obviously don't think it's a crime for him to get in the car. As soon as he pulled out of his driveway, they would have. They followed him for a period of time. It wasn't just, as soon as he got in the car and drove.
But with respect to that argument, I mean, the police can arrest people whenever they want. They don't have to arrest somebody once they suspect that there may be a crime. I mean, right? I mean, they don't have to arrest him at that time.
Well, I mean, I understand that, but my point would still be that they have to make some showing that the stop was reasonable. I think, of course, a police report, if that's all the facts we're taking, they're going to try, that's the point of the police report. But just getting into a car with a gun is not a crime. It just isn't, because you are allowed to transport a firearm. So I don't think that can be used as a basis for the stop at all. I think the basis has to be exactly what they said in the police report, that it was because they thought it was a felon in possession. And that's the inquiry that I'm.
Ms. Richardson, again, let me ask you about your understanding of the law. Is it lawful for a person to carry a firearm in the interior compartment of a car?
No.
It is, Your Honor. If the car doesn't have a trunk, it's legal to carry it in the interior compartment of the car, as long as it's placed in the furthest rear in the vehicle that it can be. Just like in a cab truck, an SUV, it just has to be as far back. So if it was a car that had a trunk, it is not legal to carry it in the compartment.
But you can't have it in the front area.
Right, but you have no idea where the gun is because they haven't observed the entire transaction. They actually left.
Well, no, but they left seeing him have a gun at his waistband.
Right, but they have.
Right?
I'm not saying they didn't see a gun. I'm saying that what they saw was not illegal. They saw legal conduct.
But what I'm
and then
asking is,
how did
based
they get
upon
to
the
reasonable
look,
suspicion?
based upon the arguments that are now going on, and I'm listening to everything, and I'm trying to figure this out, but they did see him with a gun in the waistband, and they see him get into the driver's seat and drive away, presumably with the gun in his waistband. Now, I mean, that certainly would be a reasonable thing to believe, that if they see him with a gun in his waistband, they watch him get into a car and drive away. Doesn't that suggest that, in fact, he has the gun in the front seat?
No, because I think that it has to be readily apparent, and it's not.
It's not readily apparent when they see him. It's not readily apparent when they see him with a gun in his waistband, and then they watch him get into a car and drive away.
Your
They've
Honor,
only witnessed him do completely legal conduct.
they don't see him open the back door, put it in the farthest part. They don't see any of that. He goes into the front.
My point being that he could properly store it from wherever he is in the vehicle, because it doesn't have a trunk. It's not a long vehicle.
Well, I mean, I don't know what to say. I mean, it seems like.
And he could have a CPL. It's not, he doesn't have, the police can't stop everyone and say, oh, I'm presuming you don't have a CPL. That's not how it works.
That's not this case, Mr. Anderson.
But it is.
We're talking about observations that police officers made of a person who had a gun in his waistband.
They saw a black man downtown with a gun, and they just assumed he didn't have a CPL.
And you're now turning that into, so that would mean that the cops could stop every black person in town to see if they have a CPL. They witnessed a gun in a waistband. They witnessed the man who has the gun in the waistband get into the front seat of a car and drive the car away. As Richardson just pointed out, there's no indication that they saw him open the back seat to put the gun back there. They see him get into the driver's seat. I mean, is that right?
They see him sit in the car for a period of time. He doesn't just get in and leave. There's also somebody else in the car. And he could have a CPL. They can't just presume that it's illegal conduct. It's not reasonable. Anybody that's you. I think we all know what happened here, and I know that we're not trying to accuse that, but it's not reasonable to just assume that someone commits a crime, because there is still a legal way. He could keep it on his waist. He could have it on him if he has a CPL. right? He has to commit some crime. They can't detain him.
Well, let's go back to what your motion is, because, and I'll accept responsibility for the fact that we've kind of gotten away from that. Your motion is whether or not it was reasonable for them to make a mistake.
That's correct.
And you know, and the bottom line is that, as I understand it, and you have pointed some things out about, yeah, you know, the old conviction, you know, was old, et cetera, et cetera. But I gather it's not in dispute that this is somebody who is in front of a residence. I gather they're both black. Do they also both have dreadlocks or something? Did I read that somewhere?
And Mr. Robertson has long dreadlocks. Mr. Richardson has short dreadlocks and is significantly bigger.
But the question is whether or not, if you're police officers and you see this happening in front of a residence, and then you run a check to see, you know, who lives at the residence, and you discover that it's somebody who has a prior CCW, if my facts are right here, you know, and whether or not that is enough to be a reasonable mistake, believing that that's the person who gets into the car and the person who they saw had the gun in a waistband, right? That's really the essence of your motion is it reasonable for the police, knowing that this is a person standing in front of a residence, finding out that the person who lives in the residence is also black. I mean, there are lots of black people, lots of white people, I get that, but who is also black and also has a prior firearm conviction, whether it's reasonable for them to assume that this is the guy getting into the car.
Correct.
Tell me why that's not reasonable.
Because first of all, it's in the evening. We don't know the lighting condition. We don't know to what degree and how well they were able to see him. We don't know when the arrest was. We don't know what efforts they made to see whether or not firearm rights had been restored because of the age of the conviction. We don't know that this person even still lives there, and he doesn't, but he did at the time.
Well, that's a lot of what if this, what if that. What we know is what the police did know. And what they did know is that this person who had the gun was standing in front of a residence, and they find out that the person who lives in the residence is a person who's already got a firearm offense. That's what they know. And so the question is, at that time, is it reasonable for them to think that this is a person who is committing an offense, either as a felon in possession or whatever you want to say? Your position is it is not reasonable. They had an obligation to do things like check for a CPL and all that stuff.
They had an obligation to make sure they had the right person to some degree, and that the person was committing an offense. Because,
but if they
like
think
I said,
that this,
the age of
if
the
they
offense
think that
itself,
this is a convicted felon, don't
But
they
they don't.
think?
That's not what's in the report. It says arrest. And even if it was a conviction in 2014, the rights could have been restored. They're
Right.
not permanently
But
barred.
Mr. Anderson, I mean, again, I mean, what? So they're now supposed to somehow find out before they pursue this as to whether his rights were restored?
My point is it's an arrest, not a conviction. So they, again, don't know whether or not it's legal. Yes, I don't think it's unreasonable for them to have run lean when you look at the fact that they sat there and watched the guy for as long as they did. There's no reason they couldn't have said, okay, well, let's look at this guy and see if he, made some effort. It almost looks like they justified it after, to be perfectly honest. But I mean, I can't say that, but
well, you can speculate to that, which is why I'm not asking those questions. I'm asking questions about what they believe they knew at the time, because that's the time period that I have to decide whether it was reasonable for them.
Well, yeah, I understand that, but I've made all the points as to know whether or not it was a reasonable mistake of identity. Just saying that it's a black guy with dreads is not enough. Even if,
and then we add the fact that they find out that the residents had previously been arrested for a firearm offense
8 years ago.
8 years ago.
But that's my point.
But at least you have to acknowledge that adds to the information that they have.
I would agree, but I think in order to judge reasonableness, I think that we should have the opportunity to question the officers. I mean, if Your Honor finds that it's reasonable afterwards, I mean, I understand that. I just, I think going further, I think the detention exceeded the time because they didn't make any efforts once detaining him to identify him, but
Is that part of the motion you filed?
it's not. I'm just kind of throwing that out there.
So I've already gone through what I think in general are not facts in dispute. There are some disputed facts, but I mean, as far as I'm concerned, the facts that I need to take into account, so I won't go through those again. We already discussed exactly what's going on here and the location and all this stuff, and the guy who actually lives in the residence. Mr. Anderson makes some valid points about the age of the prior arrest, et cetera. But of course, really what I have to do as a judge is to put myself in the position of the officers and whether or not they had enough to believe that this was the same person who was living in the residence and had the prior firearm arrest. And of course, an arrest is different than a conviction, but it still means that at least there was an arrest of a person who was found with a firearm. So, I mean, we're not talking about a conviction here. Let's be clear about that. We're talking about, whether there was reasonable suspicion to pull over a vehicle. Now, it is the people's burden to show that the stop was a reasonable mistake. I think that part of the law is clear. In this case, the defendant doesn't really, after this, let me say this. Both parties cite Hyen versus North Carolina, which is an interesting thing for both parties to cite since it doesn't have anything to do with this case. Hyen is a case that has to do with the mistake of law. This is a mistake of fact. And if you read Hyen, which I did yesterday afternoon, people are simply plucking out a quote from the majority opinion, which says, for years, our case law has allowed police officers to pull over people on a mistake of fact, so long as there was objective reasonableness in order to make the stop. Hyen is a case in which officers pulled over a car in North Carolina because the officers wrongly believed that the car had to have two working brake lights. And then it turns out that that's not what North Carolina law was. And then the Supreme Court expands the well-established law that police can still make a stop even if it's based on a reasonable mistake. Nevertheless, so while Hyen really isn't the case, and I'll give you what I think the cases are: Illinois versus Rodriguez, Hill versus California, Brenninger versus United States. These are all the U.S. Supreme Court cases that say that police officers can, in fact, effectuate a search or a seizure on a mistake of fact, but it has to be reasonable. And I think we all agree with that. And so, I think this is a close call, but we're still, in my view, we're still talking about reasonable suspicion, whether this was a reasonable mistake. And I'm going to conclude that it was a reasonable thing for these officers to at least do what they did. And I don't frankly know what an evidentiary hearing is going to do to change that, because again, the facts that we're all working with here, I don't really think are in dispute, and what the information that they had was. And so with all due respect, I'm going to deny the motion. Thank you.
Thank you, Your Honor.
Your Honor, the next case is the people versus Yoni Perez. This is case 2201878FH. Please state your appearances for the record.
Kim Richardson for the people.
Maluda Buxi on behalf of Mr. Perez.
Mr. Abuccia, how's that flat tire doing?
I just got it changed, Your Honor. Unfortunately, not on my way soon enough.
I get that. Life happens, and that ain't your fault to get a flat tire. So the motion before the court is a motion to limine. This is a case in which we are currently scheduled to have a trial on Monday morning. Previously this week, I made a ruling on a different motion, which was, I believe, a motion to suppress, if I remember correctly. And so I already made that ruling and denied that, and we were all there, and I don't need to go over any of that. But now this is a second motion that the defense has filed. The defendant is Yoni Perez, who is represented by Mr. Abutzia. Now, as I understand this motion, it is that the victim in the case, remember, I only say victim in CSC cases because the statute requires me to, because the statute says even if you're just somebody making accusations, that makes you a victim. Not my favorite part of the law. It doesn't seem right to me, but you know what I always say, I don't make the law, I just follow it. So I'll just refer to the victim, who was interviewed at the, I always forget what it used to be called, Child Advocacy Center, now maybe Child Assessment Center, or it's the other way around. But in any event, who was interviewed forensically. And during that interview, this is a CSC case. This is a CSC second case. It's not a penetration case, but it is an inappropriate touching case of I don't know the distinction between a girl and a young woman, and I don't remember. How old was she, Mr. Abutzia, the victim here?
12 years old, Your Honor.
She was 12. So I'll refer to her as, a girl, an inappropriate touching of a girl, or what the allegations are. So the defense gets a copy, as they're entitled, to the CAC interview, and in the report from the interview, this 12-year-old says, see if I can get it in front of me, says that she had also been inappropriately touched by others. And I think I found the paragraph. It says Mimi denied something else has ever happened with Yoni. She reported Yoni claimed he had been touching the cat when Mimi's siblings confronted him about the touching, and we've already gone down that road. But then she says, then the report says Mimi reported that touching has also happened with her cousin Angel and her stepdad Sergio in the past. And I think that's really the only relevant portion of the report. And so now the defense is saying, as I understand it, and I want to make sure, I'm obviously going to turn it over to you, Mr. Abutzia, but now the defense is saying, look, the fact that she has alleged that on at least another 2 occasions that she was touched, maybe even similarly touched, I guess you could maybe draw that inference. That's something that we ought to be able to get in front of the jury, whether as substantive evidence or at least be able to cross-examine her during the cross of her testimony about what happened in this case. Is that fair, Mr. Abutzia, the way I've characterized this?
Yes, Your Honor.
So let me turn it over to you. I mean, of course, I read everything, but let me turn it over to you to argue this.
Thank you, Your Honor. And we submitted this motion as kind of a safeguarding. It's basically our position that these allegations, this discussion that Mimi has about 2 other people possibly touching her in the past, actually falls outside of the rape statute, the rape shield statute. Your Honor, essentially, if we break it down into 2 prospective theories, first, we're talking about credibility, which could show a tendency to lie. And as such, that should be follow the rules of evidence 608, specifically 608B.
But here's my concern about that argument. I mean, I know what 608, B allows within the discretion of the court to allow specific instances of conduct. But my problem is that you don't have any evidence, nor are you even alleging that what she said happened was false. So how does this go to truthfulness?
So, Your Honor, essentially, we're looking at good faith basis as well. And so it's come to our attention. One of our investigators did reach out and was able to connect with at least one of the people that was named, I believe it was Angel, not Sergio, who vehemently, obviously, denies these allegations. So we do essentially have a good faith basis, and it's not just essentially a fishing expedition.
And so you think what, that you want to put your investigator on the stand, or you're saying no, but the fact that our investigator interviewed this person who said that never happened is enough to allow you to what? Cross-examine her, and how does that go? Isn't it true that you falsely accused somebody else of touching you, and then she says, no, that's not true? And then where does it go from there? And then what? You want to put your investigator on, and at what point does that become extraneous evidence and all that jazz?
Yes, Your Honor, and I do agree that that might be the line of questioning, and it simply might end there, depending on what that answer is. I think the information that came from our investigator at least leads us to believe that there is a good faith basis for these arguments.
But let me ask you this. I mean, there's a big difference to me about going and talking to one of these, alleged perpetrators and saying that never happened, as opposed to what we usually see when we're talking about whether this kind of stuff should come in, which is more commonly recantation. When an allegation is made and then ultimately the alleged victim says, no, it didn't really happen that way. But that's not what you're talking about. You're talking about, because somebody said, I didn't do that, that necessarily makes it a false allegation. Is that what you think?
Your Honor, I'm just simply saying that I believe that gives us a good faith basis where our overall opinion is that the rape shield statute shouldn't apply. But if the rape shield
we're not arguing rape shield. I'm not sure I disagree with you about that.
Okay.
I'm not. But I also gave the two of you on Wednesday a hot off the press case, which I acknowledge is not directly on point. But the Michigan Court of Appeals says in that case that it's really this stuff should be limited as to false allegations.
Your Honor, with all due respect, we believe that Mathis got it wrong. Mathis, they require a more rigorous showing. And we believe, our contention is that they're essentially misreading Rogers, which does cite People v. Jackson, which is a Supreme Court opinion, which essentially says that this type of inquiry should be allowed, specifically conforming to the rules of evidence.
Well, let me say this. While I acknowledge that Mathis is not a published opinion, when the Court of Appeals comes down with a unanimous opinion 3 weeks ago on this issue, I guess I'm likely to conclude that I should probably follow that. But I acknowledge that's not binding on me. So I'm hearing you. I'm hearing your argument.
And Your Honor, we would just say that an accusation of sexual conduct, it should not be considered sexual conduct. It is not seen in the court's eyes as sexual conduct. We believe that we should at least be allowed into an inquiry.
Now I'm sorry. Now you've lost me. Now what are we talking about? An allegation of sexual conduct.
Yeah, which essentially is, I guess, what this could be considered, Your Honor.
But now that gets dangerously close to the rape shield statute. It seems to me you're now flirting with rape shield, because now you're talking about trying to get into evidence prior sexual activity by the complaining witness.
And there are two kind of theories, Your Honor. One is obviously that rape shield should not apply whatsoever, follow the rules of evidence. I guess under a second theory, if it should be seen that the rape shield does apply, we have a basis of good faith. We've submitted a motion in writing, and we would just ask that the court allow us to explore this at trial.
Ms. Richardson, with all due respect, I know you've already had your children, but I get the feeling you're about to have a baby now, and so I'm now going to turn it over to you. What's the people's response to all this?
Well, Your Honor, I guess I'm going to start with the credibility issue he set up. I just because his investigator asked a person if he's a pedophile, essentially, and he denied it, doesn't mean it didn't happen, or she will say it didn't happen. It in no way proves it was false. So I don't see how that can be the swing argument on that. I think that, you know, when you follow this Mathis and everything and the law, I don't believe he can ask these questions and they can't come in.
Fair enough. Look, it's sort of an interesting question, but I mean, you could tell from my questions, I am highly skeptical about whether it's relevant when an investigator or anybody else, frankly, goes and says to somebody, so, you know, did you inappropriately touch this 11-year-old? And they say, absolutely not, that somehow makes a false allegation. I mean, I just don't think that's right. Now, Mr. Abuzia argues, well, but we're really not saying it's necessarily a false allegation, but at least it gives us a good faith basis to cross-examine her on it. But I'm not sure that it does give a good faith basis when somebody simply says, are you asking me whether or not I inappropriately touched a minor? No, I didn't. I'm not persuaded that that's enough. But the other thing is that, as I said, you know, and I also said this on Wednesday, I mean, Mathis is a case that, you know, in which one of the defendants used to work for us in this courthouse, and it's a difficult case going on in Kalamazoo. And it's, you know, and to some extent, I've been following the case, but frankly, that's not why I found Mathis. I mean, I read the E-Journal every day, and I saw this case, and I'm like, boy, you know, I better take a look at this. But in any event, I am going to follow Mathis. I mean, you know, it just came out 6 weeks ago. It's a unanimous opinion. I mean, there isn't even a dissent in it. And I think Mathis says that I'm not permitted to allow this line of questioning unless there is evidence that it was a false allegation. And again, I know that in the Kalamazoo case, in Mathis, the suggestion was that this victim was somebody who had previously recanted, but that's not this case. And so if this is simply somebody confronting somebody and saying, hey, you know, this 13-year-old or 12-year-old or whatever, you know, says that you did this to her, and, you know, what's he going to say? Yeah, I did do that to her. I mean, you know, that's just not a likely response. Of course, anybody is going to say, I don't know what she's talking, I don't know what you're talking about. I mean, that never happened. So again, I mean, you know, I think it's an interesting and well-crafted motion. I just don't think the law supports it. And so with all due respect, I'm going to deny the motion.
Thank you, Your Honor.
But thank you very much. And again, I think you presented it well. So I gather that we are starting a trial at 8:30 on Monday morning.
Your Honor, as I've talked to defense and you about this, I would ask that this be the second case up. There is a case that's similar, or not similar, but time-wise similar, and I'd ask that that be allowed to go first if it does go to trial.
Is that the case with Mr. Beeson?
Yes, sir.
Mr. Abuzia, well, first of all, let me find out what your position is on that. I mean, I think it's my call about what cases to take. But you know, would you be opposed to adjourning this so that I can try another case in which has been hanging around and for a number of other reasons, it may make more sense to do that. I also think that's likely to be a longer trial, and I'd rather get that out of the way. But where are you at with this?
Your Honor, obviously we've been preparing. We've been getting ready to go to trial, and so should the court decide that we are number one to go on Monday, we would be prepared to go.
And I don't doubt that for a second. I'm sure you'll be prepared. I'm just asking whether or not you would object if you end up being number two, and then we get you back on.
With the court's docket, I would leave it to Your Honor's discretion. I would not have a position either way.
All right. And let me ask you this as follow-up to when we were all together on Wednesday. Have you had a chance to do any checking on the immigration question?
I did reach out to Mr. Kessler, Your Honor. I have a call in with him. I have not heard back.
Fair enough. I still think it's worth you maybe finding out some stuff from an immigration lawyer, because I know just enough to be dangerous. And I am not an immigration lawyer. I just happen to know some of that law. So let's see how it goes. Obviously, we'll all show up on Monday morning. You know, maybe Mr. Beeson's case resolves, and maybe we do go ahead or something. So let's just see where that is. But anyway, I appreciate the good argument. I appreciate the presentation. Mr. Rabuzzi, have a nice weekend.
Thank you, Your Honor, and thank you for the understanding the unfavorable circumstances in the car.
Listen, I don't change my own tires. I can barely start my car. Thank you.
They had the lugs on too tight. I would have done it myself, but
did you actually just make a reference to lug nuts? Because I don't even think I know what those are. I pay people to do those things. Thank you.
Have a good weekend.
And you.
The next case is the People versus Anthony Hood. This is case 22-01379FH. Please state your appearances for the record.
Were we going to take this? Did you, Mr. Honey, did you want us to take this after our civil stuff?
Well, Mr. Slot, who you might see on the screen there, shares office space with us, and Phil's a friend. So I wanted to see him do a little dance in front of you, Judge. But
I don't make people dance. People are always smarter than I am. They make me dance. You just saw that, you know. I mean,
I'm happy to go right now. It's not a problem, Your Honor.
Well, I mean, listen. I mean, I'm fine, you know, to put you at the end. But okay. So, and I don't know if I know Mr. Slot. Maybe I've met him, but
he's good people, Your Honor.
Oh, I don't doubt that. I mean, I like everyone in your office, but in any event, so this is a motion to reinstate bond, and the defendant is Anthony Scott Hood, I mean, of course, I've read all of this. And what I do in these circumstances on bond motions is that I also get a court services report. And I did get one of those. Mr. Hunting, did you get a copy? Because I always ask them to copy counsel, but they don't always.
I did not get a court services report per se, Your Honor. I got forwarded to me, I think it was forwarded on or around September 6th, an email from Miss Fisk at Circuit Court Services, an email that was directed to your staff indicating that Mr. Hood had been arrested on a new charge and some of the background related to that charge, which I would like to address, at least as how she characterizes what took place in the recent arrest. But beyond that, no, I have not received anything additional.
And to be honest, Mr. Hunting, I don't think I've seen the email that you're referencing. So what I got is a court services report, and I'm going to not read it verbatim, but I always like people to know what I know. So what court services says is, you know, they give the background, been in custody since so-and-so and so-and-so, currently charged with possession of meth, felon in possession of ammunition, also charged as a drug second offender, and I think a fourth felony offender. They then say he's currently being held without bond after his bond was revoked due to new felony charges and continued drug use. Then they say he's also being charged with possession of meth, et cetera, which is a case that he was arrested and charged with while already out on bond. And they say that his bond has been set, I gather, in the newer stuff at $5,000 cash or surety. Then the final paragraph is Mr. Hood admitted to using meth at his scheduled appointment on April 19th, 2022. So apparently was continuing to use meth on bond. He did test clean for alcohol and drugs 1 month after that. When he was arrested on the new charges, he admitted to court services staff that he had been using meth and that he had last used meth on September 1st of 2022. And ultimately, the recommendation is that they believe that the bond is appropriate as set. So you now know what I know about court services' view of this. Now, let me turn it over to you for anything you'd like to argue.
Yeah, thank you, Your Honor. Just so that we're clear, because we're kind of dealing with two different cases.
Yes, we are.
There is a $5,000 cash surety bond on the new charges.
Right. That's the way I interpreted that.
Right. I'm not taking an issue, excuse me, with that. When you were made aware of the new charges, you revoked his bond on the, I guess, older case.
Yes.
The information I have that was, I guess, emailed to your staff is similar to what it is that you just I guess, paraphrased for the record. What I think is more important is the way that it is characterized, the new charges, the way that it's characterized by court services, because it's not as reflected in the police report. What happened per the police report, if we're going to believe that the police report is 100% accurate, and for purposes of this discussion, I guess we can take that position. Mr. Hood and another individual, a gentleman named Alex Roast, were in a U-Haul truck, and they were seen going into a storage facility, which should not be shocking to anybody if somebody is going to be taking a U-Haul truck into a storage facility. Be that as it may, the police were keeping an eye on them. They eventually pulled them over, and I'm not making a motion for suppression here, but I'm just giving you
I get it. I get it. You'll bring the motions you want to bring, but
sure.
I'm following you.
Sure. They pull over that truck. Mr. Hood is the driver. Mr. Roast is the passenger. Mr. Roast is acting strangely and appears to be under the influence of drugs. When the police have contact with him, they ask him out of the vehicle. They find a baggie underneath Mr. Roast's leg, not Mr. Hood's, but under Mr. Roast's leg. And they field test that, and it tests positive for methamphetamine. The email that was sent to your staff seems to imply that baggie is Mr. Hood's and or is associated with Mr. Hood, when in fact the police report says, and I quote, "I made contact with Alex," that's Mr. Roast. "He was given his Miranda rights. He admitted the meth under his leg was his." So the meth that they find is in fact being admitted to by Mr. Roast, who coincidentally has already pled guilty to use based on that case in the 61st District Court.
Well, I'm sorry, which one of them pled guilty to use?
The passenger.
The passenger. Okay.
Correct.
Yep.
Mr. Hood is taken out of the car. They search him. They find some stuff in his pocket, which they characterize as a pink pair of panties and a scale, but they don't find any drugs on that scale.
Last time I looked, I don't think panties or a scale are by themselves contraband. Am I correct about that?
Not to my knowledge either, Your Honor.
All right.
So in any case, he's charged with another charge of possession of meth, because they, I guess, are taking the position that both of these individuals jointly possessed the meth that was found underneath Mr. Roast's leg. Be that as it may, they did also find a locked box in the car. The police report does not indicate where that locked box was found. They don't indicate whether it was found near Mr. Hood, in the back seat, near Mr. Roast. We have no idea. In that locked box, they find various things that could be associated with drug use, drug paraphernalia, that sort of thing. I don't know whether or not they are trying to associate that with Mr. Hood, because frankly, I don't know where that was in the car, and the police report doesn't give us any indication of that. Be that as it may, what they believe, although it's not tested, and I don't have any lab reports on, they believe that they find in that box residue. So residue of what, we don't know. This is all to say that yes, Mr. Hood acknowledges freely that he's got a drug problem. Yes, apparently back in April of 2022 on the first case, the one where the bond has been revoked, he admitted, or maybe tested positive, either way, it's still an admission. He admitted that he had used then. No action was taken. No bond revocation request was made. I have no proof beyond what apparently is being stated that he admitted to anybody at the jail that he had used meth on September 1st. I can't prove that. I can't disprove that. Somebody makes that statement. I don't have any documentation to support it. I don't have any video, body cam or jail video that would indicate that that's accurate. It's possible. I don't know. But with respect to the revocation of his bond, I suspect the court took the position, hey, you're charged with another felony for the exact same stuff, we're going to revoke your bond. And I wanted the court to be aware that I think it's an awfully weak case. And the fact of the matter is that the meth that was found has already been admitted to by the other individual in the car who's already pled guilty to it.
Okay, I get all of that. I'm hearing you, et cetera. And yes, I mean, when I'm presented in a drug case with he's just picked up a new drug charge, then I probably, like most judges, would say I need him locked up. If if for no other reason than to make sure he isn't out there committing even more crimes. But be that as it may, I'm hearing everything you're saying. Now let's talk about the other problems that the court has with Mr. Hood, and give you a chance, to sort of respond. I mean, so, I've got his priors. He has an incredibly long criminal history. But
No dispute.
I only have gone back. I mean, that all starts, literally with an MIP in 2000, and it goes on a page and a half. But I only go back, usually like 5 years. It's sort of the more recent past. In this case, and this is going back 7 years, but only for one of these. In 2015, he gets a bench warrant, Wayne County, failure to appear. 2017, he ends up getting a domestic violence, which apparently is a DV third because he's put on probation for 2 years, et cetera, in any event. And then later in 2017, he pleads guilty to a financial transaction device. 2018, 3 bench warrants for failures to appear. July 2019, possession of meth, in which he got 150 days in jail. And then 3 months later, in 2019, he gets a retail fraud third, to which he pled guilty. This does not tell me what the specific sentence was. So I have those concerns as well. And while neither you nor I were there, it's not my experience that court services is going to say he admitted to using meth and that they didn't have a basis to say that. But you're right. I mean, I guess it's hearsay like anything else is, to the extent that I get reports from lots of different agencies. So, I mean, my concerns are, as I'm sure you can tell, A, this is a guy who has been in an extensive amount of trouble. B, I'm willing to concede that probably most of this, I don't know about the DV, but that probably a lot of this, the retail frauds and all that jazz, is because he's a drug addict. I get that too. But I'm also, of course, concerned about the fact that apparently he, and I'll give him credit for being honest. I mean, he admits that he's still using, or at least he certainly admitted that when he was arrested, he was using. And so those are the concerns about whether or not, it's a sensible thing for me, to suddenly give him some sort of a bond. I mean, I'm going to give him some sort of a bond. And then, of course, I'm always in the position of, I don't represent him, you do. And I know what your job is, Mr. Hunting. You're very good at it. But there's always a part of me that also thinks, if he's out, he's going to make this worse. But but that's not my job. I don't know whether he would do that, but I get concerned when I see this kind of stuff. So that's it. Respond.
If I might, Your Honor, when we are provided the initial discovery documents from the prosecuting attorney's office, as you may be aware, we are typically provided with some criminal history on our client.
I am aware of that.
Yeah, I am looking at the criminal history that we've been provided for Mr. Hood. And obviously I'm aware of the first case because I represent him on the first case and I represent him on the second case. I show no domestic violences whatsoever. I show nothing in 2019 that would be a retail fraud. I show a variety of criminal offenses, no question, most of which, if not all of them, are either retail frauds or forgeries, uttering and publishing, those sorts of things. I don't, and drug offenses. I see nothing that's violent in nature. So if court services has found something that is not in the documentation that I've been provided, I can't respond to that. I'm not saying you're wrong.
I get that. I have to tell you that I've been doing this a while. Court services stuff is more accurate and better. What I can read to you is that the domestic violence, October 10th of 17, was in Montcalm County. He got 2 years of probation, 13 days in jail, fines and costs. Then later in 17, a financial transaction device, 63rd District Court pled guilty. And then 2019, the possession of meth, which you may well have represented him on, I don't know, in which he got 150 days. And then and then later in 19, only 3 months later, the retail fraud third, again, 63rd District Court. And it says pled guilty. But I only have in front of me, I also, you know me, I didn't do a lot of state work, but I did do some state work. And I always thought that, well, first of all, you can't run guidelines. You used to get accurate stuff. And I used to be very frustrated about the fact that I never did get accurate stuff. So how do you run guidelines if they're not giving you everything? And then you find out later, oh, that's not how I scored them. But anyway, I don't want to get, embroiled in that. I just wanted you to know that what I have in front of me does suggest that there are some concerns. So what are you asking for?
Well, Your Honor, initially on the first case, the one where bond has been revoked, it was a $2,500 10% bond that was posted, and he was out for an extended period of time. While he may have failings to appear in various other courts, and again, I can't speak to that, I will take that record as being accurate. He has not failed to appear in the case, either one of the cases that I have been representing him on. And we've had, if you could take a look at the court file, or if you have looked at the court file, we've had a number of status conferences before you. We've, I think, even had a couple of times where jury trials have been scheduled, but they've been adjourned because we weren't the oldest case. So he has not had any failings to appear in this particular case. As the court's aware, under the court rules, there are a certain number of factors, identified factors, that you are to take into consideration with respect to setting a bond. Prior criminal record. I'm not going to argue the fact that he's got, frankly, a terrible criminal record. He's got criminal record in the state of Michigan, and I believe criminal record outside of the state of Michigan.
Yeah,
but
I've got some stuff in Ohio and Indiana.
Sure.
So you're right about that.
Yeah, but the vast majority, if not all of them, based on what I have, and it's only what I have, they are not inherently violent in nature. They are theft offenses. They are forgery offenses. They are the type of offenses that would be indicative of somebody with a substance abuse problem who's trying to generate funds in order to get drugs. Again, B would be appearance or non-appearance in court proceedings and flight, risk of flight. Again, in this case, he has not missed anything. I put right in our motion that his family lives here. His wife lives here. She is with child. They have a home. He is the primary income earner in that home. And with him being in jail, it subjects them to risk of losing the home. No question, he's got he's got a history of substance abuse. We can't avoid that. Not even going to try. I can tell this mentally. I have not asked for a competency exam. He understands what's going on here. He is not a dumb individual. He's just got himself a drug problem. The seriousness of the offense. Before this new charge came up, I had his guidelines scored at 5 to 23, which I guess is what it is, and maybe it's wrong if there's a whole bunch of criminal history that I'm unaware of. But
well, whatever. But we both understand that's a straddle cell. I get it.
Yeah. Employment. He was working. I think what he does is he kind of does odd jobs under the table is what he principally does. Availability of members of the community who could vouch for him. Again, we're talking about family here, a wife here. I have spoken to the wife on the phone. I've never met her in person. So I can't tell you whether or not I feel that she's an upstanding member of some society, but I don't believe she's got any significant criminal record, not as far as I know. Same thing goes for ties to the community and any other facts that the court might consider for purposes of making this decision. So ultimately, Judge, what we're asking is that you reinstate the $2,500 10% bond. If you don't feel that that's appropriate, any sort of bond would be appropriate from our perspective, as long as it's a reasonable one. As I said, it's $5,000 cash surety on the new charges. You could make it $5,000 cash surety on the original case, or you could keep it as is. I just want to have this guy at least have the ability to bond himself out of jail. He might not be able to do it. I'm appointed. They might not have the funds, but I want to at least give him the chance.
Fair enough. Ms. Richardson, people take a view on this one?
Really don't, Your Honor.
Fair enough. Look, taking everything into account, here's what I'm going to do. So on the case, I'm going to set a $10,000 10% bond. I know, Mr. Hunting, you're an old timer. You know what that means. He does not have to go to a bail bondsman, but he would have to post at least $1,000. He, friends, family, whatever. And I'm also going to order that he not be released unless and until he is fitted with an electronic monitoring device.
And that would be would it be GPS or would it be Scram, Your Honor?
I didn't even really think about that. I mean, my impression of all this is that he doesn't, alcohol isn't his drug of choice, that it's mostly drugs. And I think Scram is really about alcohol, isn't it?
It is, but I just want to make sure that.
No, I'm just talking about a regular EM. I mean, a temp, and I incidentally, and also I just went through this in a probation violation hearing yesterday morning. That stuff is not as expensive as it used to be. And I'm sensitive, of course, to people in poverty, and I don't know anything about this guy's circumstances in particular, but what I was told yesterday is that there's like an initial charge of, I don't know, $30 or I don't know what it is. There's an initial charge, but it's not as much as it used to be. And then it's $30 a month. And then if he can prove indigency, he may be able to get some of that waived at the end. So all I'm saying is I want to keep track of this guy. I don't think an EM is going to be an awful burden, but I also don't know what the household income is.
Fair enough. I will reach out to his wife and explain everything. And because she's the one who's obviously going to be taking care of this one way or the other, at least to get him out.
Understood. Anything else?
Do you need me to submit an order or is this fine?
Let me look to the people who run my court. That would be my staff.
Well, I can send over a greeter.
We'll just simply send over a greeter. No need to present the court with an order.
Okay, sounds good.
Have a nice weekend.
Yeah, take care, Mr. Slot.
Will do. Ms. Richardson, are we now done with our criminal stuff? Ms. Richardson, have a great weekend.
Thank you. You too, Judge.
Okay. See you Monday. All right, folks. I know many of you have been very patient, but we do take our criminal cases first. We are now moving on to the civil cases. I always think, if I was sitting here listening, I'd say, boy, just motion day for these circuit judges, pretty nutty, bunch of stuff, but let's move on.
The next case, Your Honor, is Advisacare versus State Farm. This is case 2100490NF. Please state your appearances for the record.
Good morning, Your Honor. Steve Hulst for the plaintiff.
Good morning, Your Honor. Sean Zayas on behalf of the defendant, State Farm.
And good morning to both of you. This is a case that has been ongoing for some time. The motion before the court is Mr. Hulst on behalf of Advisacare's motion for the entry of a final judgment. I got a defendant's response and brief, and then I also got a plaintiff's reply brief. Mr. Hulst, I think I get the argument, but that may not be right. Let me turn it over to you. It's your motion.
Sure. Thank you, Your Honor. As Your Honor knows, you previously granted summary disposition under the 3157 based on Medicare amounts payable. We now have the Guardianship decision that I know the court's familiar with, which indicated those fee caps and schedules could not apply retroactively to Mr. Baldwin. And so we're back to the reasonableness standard under the old No Fault Act. The evidence is clear that there was no dispute on the reasonableness of my client's rates. In fact, I think the court concluded that as part of its previous ruling as well. And we've attached an affidavit from our controller that calculates what's owed through that September 18, 2022, which is $82,775.74. We've calculated the penalty interest as $7,214.17. There's been no dispute from State Farm on that calculation. And I guess in my mind, from reading the response, it seems like the major dispute from State Farm is having to pay attorney fees under the No Fault Act. Our position, Your Honor, as well. Certainly, the new law has caused great confusion and it's not well worded. And I understand there's questions about that. The testimony from the adjuster in this case, in my opinion, showed that State Farm really didn't have any legitimate reason for paying the way they did for the last year. The adjuster had no comment on Medicare amounts payable, no comment on Advisacare's charge description master, both of which would support full payment of Advisacare's reasonable rates. And I think one other factor is relevant on the attorney fee issue, Your Honor, is even after we get Andary, even after we get the Supreme Court's denial of the defendant's motion in that case to state the precedential impact of that case, even after we get a diffs bulletin, which directs insurance companies like State Farm to go back and reprocess, we're still here fighting. And I don't believe that's reasonable given the clarity of the law. And so we're asking that the court grant our motion and enter the proposed judgment that we submitted.
So let me ask you a couple of questions, if I might.
Sure.
As we all know, you guys know this better than I, but I feel like my life is no fault sometimes, but reasonableness, of course, is generally a question of fact. And that means if it can't be resolved, it's generally a question for the jury. My first question to you, Mr. Hulst, is, because I'm certainly going to ask Mr. Zayas about this. As I read Mr. Zayas's response, I think that State Farm is now saying, yeah, I think it was an adjuster, the guy who you deposed, the adjuster certainly did say, that it believed, or he believed, or State Farm, he's speaking for State Farm, did believe that was reasonable. But now I gather, and I'll obviously hear this directly from Mr. Zayas, that State Farm is saying we no longer think it's reasonable. And I'm certainly going to ask Mr. Zayas if he has any authority for that proposition. But what's your response to that? Are they somehow bound forever to the testimony of one of their adjusters that was taken a long time ago, and therefore they can never come and say, we no longer think that is reasonable? I mean, it doesn't feel, it smacks of waiver or estoppel, but I'm not sure those things actually apply here. So I'm curious as to what your response is to that.
Yeah, so the adjuster did very clearly testify at his deposition that the rates charged by AdvisoCare were reasonable. In fact, they never disputed those rates. They fully paid those rates. And I think the important point there, Your Honor, is that the adjuster's testimony about paying those rates and finding them reasonable was under the old No-Fault Act, which we now know applies again.
No, I get that, but I think the question I'm asking. Does that mean that they're forever bound?
That's an admission by a party. I mean, that's their adjuster. He was the gentleman who, in his deposition testimony, who acknowledged and agreed, yep, I'm the guy at State Farm that determines what to pay, when to pay it. I'm the adjuster. I'm in charge.
Well, I get that it's an admission by a party opponent. I mean, that, of course, you're absolutely right about that. I'm just trying to figure out whether that means that for now, until this entire matter is over, that they're not able to say, we no longer believe that is reasonable. We now believe that this number is reasonable, whatever the number is. And therefore, from this point forward, we may have to concede that we're bound on the previous bills that our adjuster addressed, but we now believe that there is a question of reasonableness. And your position is, well, it was an admission by a party opponent. That means they're stuck with it.
That, Your Honor, and as Your Honor knows, this is a litigation process where there's timeline here, where we have discovery, where we ask questions, where we try to narrow the disputes, and that's exactly what I tried to do in this case, because I always want to know, hey, at the outset, are you disputing our rates? Because if you're disputing them, I'd like to know the basis. Show me the evidence. And throughout the entirety of this matter, there's been no evidence from State Farm ever to say, hold on, we find that these rates are not reasonable given the level of care. That's never been presented. And as we sit here today, even in response to this motion, there's no evidence in front of you. There's no market survey. There's no nurse case manager report saying, well, hold on, I don't think these rates are reasonable. The record is devoid of that information. And so that's why I do believe that testimony stands unchallenged.
On the issue of fees, which also generally is a question of fact, if the parties cannot agree on that number, if they contest the fee provision, does that mean that I'm obligated to hold an evidentiary hearing to determine reasonableness?
No, I don't think you're obligated to, and I don't recall seeing any requests. Maybe I missed it in the response. I don't think you're obligated to. You have my affidavit. You have what my client has paid in this case. They've not raised any challenge to that I recall. I haven't seen any affidavits or information to suggest they're disagreeing with the hours or the rates. I suppose if Mr. Zayas had a good reason for making that request today and Your Honor wanted to do some kind of evidentiary hearing, you could, but.
Oh, I don't want to do an evidentiary hearing. I just do what the law requires me to do.
And I don't want to do an evidentiary hearing either. And most times nobody does, but I mean, based on the record, I don't think they've been challenged and no evidentiary hearing's been requested. And I don't think you're necessarily obligated to. I think you're obligated to do the factors that all those cases discussed in terms of evaluating the reasonableness and the hours, et cetera. But again, that hasn't even been challenged.
I mean, it's, whatever that case is, it's like a Purgu. Isn't Purgu the
Yes,
case now?
yes, that's the
Something
one.
like that.
Yes.
It used to be another case and it's pretty much the same test, but
Yeah.
anyway. Okay. Let me ask you this. I don't know what the right word is. I guess I'll just downplay it and say surprised to find out that an interlocutory appeal had been filed in this case, because I wasn't aware of that. Were you?
I was aware of that. I was surprised it was filed too. I'm not.
It's not about whether. It's not about whether it was. I was surprised it was, filed in that sense. I'm surprised that nobody had the courtesy to tell me that they had just appealed my decision. But I guess that's the way that goes, eh?
I think you're supposed to be notified if there's an interlocutory appeal filed, but I'm not aware of that ever having been done either. The appeal's done nothing. It's my knowledge. It's just sitting there, and I obviously can't guarantee what the Court of Appeals are going to do on an interlocutory application on a summary disposition motion, but I highly doubt they will take that up.
Look, let me be clear about this. I'm in my 14th year of being a judge. I couldn't care less who appeals me. My God, the number of decisions I make in a day, let alone in 14 years. This is the second time this has happened, though, in which it just strikes me as being courtesy to at least let the trial judge whose order and ruling you're going to appeal send a copy of that. But I'll ask Mr. Zayas. I've been pronouncing your name Zayas, but he's pronouncing it Zayas, and I want to get it right. Which one is it?
You were right the first time, Your Honor. Zayas.
It is Zayas. Okay.
Yes.
All right. Fair enough.
But I accept Zayas.
I mean, that's fine. People are entitled to, I got a name that people mangle. So, I mean, people, it's Denenfeld, it's Denenfeld, it's whatever. We all have these names, except Hulst, who comes up with an easy one. His
Right.
parents treated him better than my parents treated me. And so, okay. Now let me turn to you, Mr. Zayas, and you do not have to respond, but I would like to know what's going on in my cases, but I'm not going to make any more of an issue of that than I've already done. Let me ask you. I'll start with a question that is similar or identical even to what I've asked Mr. Hulst, and that is, do you have authority that says that in the middle of a case, after your party has said that those are reasonable rates, that you can suddenly say, meaning your client, that we no longer think that's reasonable?
Well, Your Honor, let me go back to the appeal issue first. We have co-counsel that's handling the appeal. I don't know what the court was expecting or would have thought would have been noticed, except for I think we have to, whatever co-counsel handling the appeal would have had to file the notice of the application and those things with the circuit court as well as the Court of Appeals. So
I am not advised.
I'm not sure what
the only point
the
only point I'm making is, if you're going to appeal a judge, and you have every right to appeal any decision that I make, dropping the judge a copy might be the right thing to do, but it may not be required, and we're moving on from that. Get to my question.
Well, and so thank you, Your Honor, for knowing that, because if there is a next time, and hopefully there's not, then that would be, we would make sure that's done, Your Honor. So
to my question about what authority do you have?
Well, so it's very clear, Your Honor. So let me go back. I got to answer that in a couple pieces, okay? First off, when Byron Nickens is testifying, when Mr. Hulst deposed him in this case, It was long before Indari, and it was after the fee schedule was in place. So he's testifying in that context. When he says 29.95 an hour and 50, and then later 55 an hour, that those two rates were reasonable, those are the two rates State Farm was paying before the fee schedule took effect. What's he going to say? We're paying an unreasonable. I mean,
and now we know that the fee schedule never should have taken effect.
Okay, so the underlying, but the court, Your Honor, your ruling was based on the fee schedule being in place. It wasn't simply that, well, he agrees that $55 an hour and $29.95 an hour, those are reasonable, therefore they want those. And therefore, so I'm granting summary dismissal. It's more complicated than that because, as you'll recall, Your Honor, then we're also arguing, even though they didn't ask to be paid the Medicare rates, AdvisoCare has asked the court to find that the Medicare rates would have applied. So that's what the issue is on appeal. So then Indari comes in. So yes, you have an adjuster saying that at the time that they were paying $55 an hour and $29.95 an hour for the home health aid, $55 for the LPN before the fee schedule takes effect. Now, after the fee schedule takes effect, you have testimony and you have from the deposition and you have an affidavit. Why didn't you pay Medicare rates? Well, Your Honor, this isn't the only case where there's a dispute, and I'm sure Mr. Hulse is on appeal on other cases where they're arguing the same thing, whether the Medicare rates for professional attendant care apply. And when you've briefed all that, so if there's the dispute there, that's a legitimate dispute, whether State Farm is right or wrong, it's a legitimate dispute.
Well, let me ask you this. I mean, I haven't gone back and reviewed that entire deposition, at least this time around. Did your adjuster testify that this is reasonable only because the rates have changed?
No, Your Honor. He was asked, Mr. Hulse asked him what they were paying before. And he said, we were paying $55 and $29.95 an hour. It's a historical statement. Yes. And he says, what's he going to say? No, we were paying an unreasonable rate. Well, the argument now is that
What he's going to say is the truth. He's under oath. So keep going.
Right. Okay. So he says they're paying a reasonable rate. No one's arguing that he didn't testify to that. What we're saying now is, so then Indari kind of jumbles all this up, Your Honor, because you ruled on the assumption that the fee schedule applies and that Medicare actually has rates that apply to this, even though I don't know how AdvisoCare is trying to use them to get their bills paid. So there's the dispute about whether the Medicare rates even apply, and that's a legitimate dispute about a statutory interpretation. Now the statutes.
Now
we say it's gone.
Now we know that they don't. If I read Andari, however it's pronounced, if I read that correctly, right? We now know that.
I think what happened. This would be my understanding, Your Honor, that for cases where the accident predates the June 11, 2019 amendments that all took effect, the whole no fault reform, quote unquote. We are now outside of that. We're back to what is reasonable now. Well, what is reasonable 3 years ago? I don't know if that's the same now. I mean, that's now I think kind of to your point, Your Honor, I don't know that we can't say because those were the reasonable rates 2 years ago that they're reasonable now or not. There's always, with all due respect, AdvisoCare saying that they'll take $55 an hour for the next.
Well, with all due respect, Mr. Zayas, my question to you is still the question I have. Do you have any authority that says that after determining that something is reasonable as a rate, that
Correct.
At some point in the future, you can say, you know what, we don't think it's reasonable now?
Well, yeah, I mean, I suppose I don't have authority for that, but I mean, facts change. I mean, something could come up, but no, I don't have authority to say, I don't know that you're bound forever, but I don't think that's really the issue. I think what the real issue is that at the time of when you're adjusting the claim, what facts do you know? And that dovetails with the attorney fee issue. And it's the same with adjusting. When you're looking at what an adjuster does, you look at the facts before the person at the time that the claims decision is made. Now, and in this particular case, we can see that not only does the law changes in January or in June 2019, then you get a fee schedule that kicks in July 2021. Then you get Andari a year and like 13 months after that. You've now had the law changed 3 times in the span of 2 years.
Yeah, but have the facts changed?
His underlying, I don't know that his underlying conditions have changed. The facts changed with regard to the rates, who's doing what, I mean, are they saying that the rates never go up, never go down? They can't ever go up or down?
I don't know. Let me ask you another question. Did State Farm simply ignore my previous ruling in this case?
No, I don't. Well, I don't know why you say that, Your Honor.
Well, because, I thought my previous ruling was that State Farm was to continue to pay the amounts previously conceded were reasonable, but I think I read something suggesting that hasn't always happened.
Well, I don't know what always meant. What was supposed to happen, Your Honor, and was plaintiff was going to move. This motion was supposed to be filed 5 months ago, Your Honor. We were going to deal with this in the context of Mr. Hulse's motion for entry of a final judgment and see what his numbers were and see where the parties were at. That was supposed to be the follow-up, and it took months for that to happen.
Yeah, but
that's supposed to be resolved this way.
I have to tell you, Mr. Zayas, I mean, I think I'm asking pretty straightforward questions, and I don't feel like I'm getting a lot of straightforward answers. I issued a rule. Sir, please. I issued a ruling.
Sure.
When I issue a ruling, I expect people to follow it. Now, as with respect to the appeal that you filed, you certainly didn't ask me for a stay. Did you ask the Michigan Court of Appeals for a stay?
I believe there was I believe there's a request for a stay, but I don't know that for sure, Your Honor. I can't speak.
So you're not sure if it's even been asked, but we certainly are sure that one has never been granted. My ruling is in effect, and I'm trying to understand whether it has been completely followed.
Well, I couldn't tell you, Your Honor, other than I thought that was the mechanism for us to deal with this. Was there's going to be a motion for because here's kind of what's going on, Your Honor. Our math has not been working out. What plaintiff is saying has been paid, what they're saying has been paid. We've had to try to get on the same page on that. So it wasn't just as simple as somebody following or not following your ruling.
I don't know. It's pretty simple to me that when a judge enters an order, and says, that, essentially, here's what the rate should be. Either you follow it or you appeal me. And if you appeal me, which again, you have every right to do,
Sure.
if you want to get in the way of my ruling, then you have to move for a stay. And the last time I looked at these rules, you have the choice. You can either take it to me first. You don't have to do that. Or you can ask the Court of Appeals. But unless and until a stay is issued, my ruling has to be followed. And I'm trying to find out whether my ruling has been followed to the letter.
In Your Honor, I can't tell you what they were paying after your ruling, Your Honor, other than what shows up.
How can you not know that? You represent them.
Yeah, I did not make an inquiry as to what they were paying afterwards, because what Mr. Hulst and I were supposed to do was compare our numbers. State Farm was to continue to pay. As far as I know, they continued to pay. I don't know what they've paid because I didn't go back and look to see what they've paid since your ruling versus what they paid before the ruling.
So let me ask
No
you,
one said they haven't paid, by the way.
Let me ask in a different way, Mr. Zayas. When a court enters an order and it affects your client, I presume that the first thing you do is to say the court has just issued an order and we need to start following this immediately. Did you do that?
Yeah, I'm sure I would reported to him what the ruling was, and yeah, and it part of the response.
But apparently you never followed up to see whether they were in fact complying with the rule.
I cannot swear to this court that I called and said, "What are you paying now?" No, I didn't do that.
Okay, all right, fair enough.
Yeah, and I wouldn't represent otherwise. So
No, I appreciate that. I mean, I'm not asking you to lie. I'm just trying to figure out, usually, when a judge enters an order, he or she kind of expects it's going to be followed unless and until it is stayed or reversed. But that's
Sure.
just what I learned once. So we now know, under however you guys are pronouncing it, Andari, it doesn't matter to me, but in any event, we now know that the fee schedules never should have applied. As I read that case, that case is really mostly based upon a violation of the contracts clause. And my understanding is that the ruling in that case was that people who had no fault insurance contracts, were not to be affected by the no fault amendments, because the Michigan Court of Appeals just ruled what it ruled, which is that it never should have had any effect on policyholders at that time. Is that how you read that case with me or not?
I think that's essentially it. What I would say, Your Honor, is that the court was suggesting that you had a contract before the statute changed, before the reform.
That's correct.
Before the amendments took effect. And that you lose the benefit. This is the writ rationale, right? That you lose the benefit of your bargain if now you're not getting, now you're somehow getting less or different or no benefits because of the changes.
I think that's
because
fair.
of the retroactive application.
Yeah,
So,
I think that's fair. That's how I read it.
says.
Yeah, okay. All right. So I've been asking you questions. Let me turn it over to you. Give you a chance to say whatever you'd like me to hear.
Well, I think, Your Honor, the law is, Andari is the law, Your Honor. You didn't hear us in here say that you don't follow Andari or it doesn't apply. What we've suggested is two things. The motion, to the extent there's an attorney fee, and I think Mr. Hulst is right, that was the main focus, because even though we re-argued our position or restated our position with the court's underlying ruling, pointed out that there's an application for leave, which is still pending, pointed out that Andari is supposed to be heard by the Michigan Supreme Court
And as I understand it, they granted leave but denied a stay, if I get that right.
That is correct. And Andari is the law. Your Honor. It is the law unless and until the Supreme Court says it's not.
Fair enough.
And that's part of our point, though, Your Honor, that especially with the attorney fees, Andari wasn't the law until August 25th. So you've got State Farm has been making claims decisions and making payments based on what the law was up to the point that the fee schedule kicked in, and then after, following what they understood the law to be. That's not unreasonable, even if they're wrong about it.
Explain this to me, because I guess this is part of what I don't get. Now that we know that the Court of Appeals has held that the fee schedules did not apply in this case, what exactly has changed as of July 1st, 2021, that would suddenly say that these rates now may not be the rates that are reasonable?
I don't know that anything's changed about that. I don't know that any facts have changed that would change the analysis of the reasonable rate, other than I think what our argument really is there is, if you don't, now that Andari says the fee schedule doesn't apply, you go back to square one, which I think is kind of actually what Mr. Hulst is saying. So
I would agree. I think I'm hearing him say that. I think that's
so.
right.
So I think to some extent that's true. Now, you did rule, Your Honor, that you felt, because there had been an admission by Mr. Nickens that those rates at the time were reasonable, that I think that's why you ruled that they would still apply. But there was more in your order than that, Your Honor. There was also the rates, there were issues relating to Medicare.
That's true, because at the time, I assumed that part of my job was to have to try to construe the amendments. I mean, whether I got it right or wrong doesn't matter to me. I mean, I do the best I can, but the bottom line is, of course, I mean, I had to address that because those amendments were still valid and because the parties were arguing about that. I think we all understand that. But that part of it, I think, is probably, frankly, moot at this point, because there's not even a controversy about that. And if the law, if Andari or Andari had been decided beforehand, which, trust me, I certainly wish it had, then my law clerk and I would not have spent the hours that we spent trying to figure all this stuff out and all that stuff. But I mean, I understand and I get it. And I think we all understand that the effect of Andari is those things never should have taken effect on based upon a retroactive analysis. Whether we agree with it, whether we don't, we're all bound by that. And so that's one of the reasons why I just asked the question, which is, well, now that we know that those amendments never even should have taken effect as to what has happened that would change the reasonableness of the rate. And I think you've answered that question.
But
again,
Your Honor, may I
of course,
very briefly?
Yes.
But consider too that there are appeals implications. I can sit here and say that Andari is the law, but I don't want to prejudice my client and say, I don't know what they're doing in terms of appeals in this or other cases that relate to Andari. So I'm not going to say that. Yes, the court was right. I mean, it was a 2-1 decision, and it's going to be heard by the Michigan Supreme Court, which it should, because it's a pretty big.
Why would any of us say yes, it's right? I mean, unless you got a dog in the fight. I mean, if you're a plaintiff, et cetera, et cetera. That's not the way I look at the law.
But I think they would argue that the fee schedule does apply, and that they've
already lost that fight at this stage.
At this stage,
and it seems to me, I mean, look, none of us can read tea leaves. I mean, for God's sake, the Chief Justice is leaving, and none of us expected that either. But the bottom line is that Andari is the law, and that at least one of the parties in that case asked the Supreme Court to stay it, and they said no. So the only thing a judge in my position can do is to apply Andari as what it is, binding law. And I assume both of you would agree with that. Well,
you have to follow Andari.
I can't predict none of us can predict what the Michigan Supreme Court. My God, I stopped doing that, decades ago, about trying to predict what courts are going to do. It's a little easier sometimes about, who is the draw on the panel or something. But the bottom line is, and especially in light of the fact that the Chief Justice is leaving, and none of us know what's going to go on with that. But again, I mean, I think we all understand, of course they could reverse. I don't, and it's easy to read too much into them denying the stay, because obviously, one could argue that means, well, at least we're not going to stay what the Court of Appeals did. And that must be an indication. I'm also too old for that. It's not an indication of anything other than they made a decision that let's let this be the way the Court of Appeals decided it until we have a full chance with full briefing and everything else to make that decision. I think we're all on the same page about that. What else would you like me to hear, Mr. Zayas?
I think just to wrap it up, Your Honor, I think what you just said is you gave up years ago trying to guess what the Supreme Court would do. That's really the point, Your Honor. The law, again, with respect to the attorney, Your Honor has already ruled on the underlying issues, Your Honor. We've tried to preserve those for appeal. We've tried to point out what we think we pointed out our positions on those. I think that's as preserved as it can be. The attorney fee is different, Your Honor, because just like you said, if you were to award an attorney fee in this case, what you're saying is that State Farm should have known that Andari was going to come down, and that a duly, at least we thought, a duly statutes duly enacted by our legislature and governor don't apply, especially if they've been used for a year and a month before that came down. I mean, people have been paying on the fee schedule. I think Mr. Hulse would tell you was hurting his clients, or I think that's what they typically argue. So to say now, well, you should be penalized and pay an attorney fee because Andari came down and you should have never been paying the rates based on a fee schedule under 3157. I mean, it's like an ex post facto law on the criminal side. You're punishing someone for not, and make no mistake, Your Honor, attorney fees under the No Fault Act, that's, they're called penalty interest and in their sanctions under 3148. So it's a punitive measure. It's not to award attorney fees, and it's for unreasonable behavior. And I don't think following the statute, whether it's statute was later found unconstitutional, is unreasonable. So just like
Well, the bottom line is that we just had this discussion. I don't need to belabor the point. My guess is that, and I've not seen the papers, my guess is that the motion for a stay made all these arguments, and the Supreme Court said, no, we're not going to stay. The law changes, and the law changes, and it has effects. And none of us can predict what higher courts are going to do. What I do know is that right now, it is what it is. And Andari is the law.
Oh, yeah, but that is, I guess I'm just going back to the attorney fee portion.
Well,
it wasn't the law until it was, and therefore they shouldn't have to pay an attorney fee for following what the law was before Andari. That's my point about Andari.
But if,
yes,
if Andari says that the amendments never should have taken effect at all, then, I mean, how is your client being punished? Because in effect, Andari is saying it never should have taken any effect at all. And so the attorney's fees law always should have remained as it was, as it now is again.
But how was State Farm supposed to know that when it was making payments?
Because they're in the insurance business, and because they know this stuff gets litigated all the time, you know, just like Mr. Holst, who's on the other side, knows all that. I mean, when we have appellate decisions that are published and binding, it's always going to affect somebody. And somebody is always going to be able to say what you're saying, which is, yeah, but that wasn't the law at the time. The analogy to ex post facto is a specific federal constitutional provision that applies in criminal cases. But I hear your point. I mean, in effect, you're saying, gee, you know, it's just not fair. Why weren't we applying the law at the time when it applied? And I'm sure, again, this is an issue that will have to be decided at some point by the Michigan Supreme Court. And I presume that will be an issue they'll have to address.
Now, I mean, in November, Your Honor, if an insurance carrier is not following Andari, that looks unreasonable. But in July of 2022, before Andari comes down, what are they supposed to be paid?
Well, first of all,
that's my point about the attorney. That's
I get
to
it,
the attorney.
I find it a little hard to believe that State Farm and most of the other insurance carriers were not aware of the fact that this stuff was being litigated and being litigated hard. Everybody knew on one side or the other that this was going to have impact, which is why it has been so hardly fought about this stuff. So, I mean, I understand what you're saying, but if Andari says what I think it says, which is none of this stuff ever should have gone into effect, it never should have affected anything because it's being applied wrongly when people already had existing policies of insurance. I mean, you know, it's not like both sides, Mr. Hull's side, your side, we're not aware of the fact. I mean, my God, I mean, some of the worst fights I've had, and I don't mean that personally. I mean, I'm just saying some of the hardest fought fights that I've had as a judge in the last couple of years has everything to do with no fault amendments, you know, all of this kind of stuff. So we all knew that there were a lot of issues at play that we were going to have to wait and see what happened. But I hear your point. I do.
But how would State Farm know, Your Honor, that which panel is going to be drawn and how 2 out of 3 judges are going to vote on the retroactive application of one part of the no fault?
Mr. Zayas, I thought I just tried to address that, and then I think, you know, it's fully addressed, which is everybody knew this stuff was being litigated. Nobody could predict the way it was going to come out, but everybody knew whichever way it came out, it was going to affect carriers and it was going to affect plaintiffs and first party benefit claims, right? Everybody knew that.
And that's why it has to go to the appeals courts, Your Honor. We need answers. Everybody needs answers on these questions.
And it's already there, my friend. And the Michigan Supreme Court has granted leave. And they will tell us what the law of the state of Michigan is. I mean, again, we're all there. Look, I've got a lot of other people waiting. I still have, I think, one more. I think I do. Oh, no, they settled that case. I'm sorry. Yesterday afternoon, they settled that case. No, do I have like a default judgment one? I'm sorry. I just need to make sure that I know what, because I've also got guardianships and people in the courtroom.
No, you only have Mr. Slack. We have Mr. Nordquist on Farmers versus Gary Bartz. And we have Mr. Slot on.
Okay, that's right.
Do we have-
Okay, so bottom line is, look, I appreciate all the briefing and all that stuff. I'm not going to make a decision today. I'll get something out. I take some pride in getting things out in a timely fashion, so I will do my best to get something out as quickly as possible. I mean, I think the attorney fees issue is, you know, is sort of a, you know, an interesting issue about, you know, how it's going to play out, whether it's fair or not fair. I'm not entirely persuaded about fairness because it's all about whichever side wins. The other side says, well, that's not fair. And then that's kind of the nature of how all this stuff goes. But, you know, but nevertheless, so I'll get something out on these issues and we'll take it from there. Okay. Have a nice weekend, guys.
Thank you for the hearing, Your Honor.
You bet.
See you guys.
See ya.
To the guardianship, it's been a very long day and I'm not done yet. I'm not going to take a break, but I still have some stuff I have to take care of. So I appreciate your patience. The next case is Farmers Insurance Exchange versus Carrie Ann Bartz. And I wonder if I could get appearances for the record, please.
Good morning, Your Honor. Adam Nordquist for Plaintiff Farmers Insurance.
And do I have Ms. Bartz with us?
I don't have any contact with her. I haven't had any contact with her. I
No,
suppose
that's fine. I mean, I have, you know, some people are still participating by Zoom, some are in the courtroom, and I now have a courtroom full of people. So I just wanted to make sure as to whether Ms. Bartz was or was not here. It does not appear as if Ms. Bartz is here. I've spent some time on this. Let me see if I get it right. The motion before the court is Farmer Insurance Exchange's motion for the entry of default judgment. Whenever I get a motion for the entry of default judgment, probably like most experienced lawyers, the first thing I do was a default properly entered, which it appeared to have been here. And secondly, that portion that a lot of lawyers screw up, which is even though you may have defaulted a party, they are still entitled to receive notice of everything since then, which includes getting notice of the request to convert the default into a default judgment. I did look into the file. It does appear to me as if both of those things were done. And so that's the first order of business, which is to be fair to the defaulted party in the case. So Mr. Nordquist, having said that, I think you and I had a telephone conversation and I did get your message, your subsequent message about that. And it was just a discrepancy in numbers. And do I understand correctly that it turned out that the number I had come up with is the number that you agree should be used?
No, Your Honor, actually.
Is it the other way?
Yeah, yes. There's actually, I can explain it away if that's easier, if you have the motion in front of you. But
you know, I have the motion in front of me and I really don't want to spend a lot of time on the motion. I just want to remember, I mean, we're talking about, I don't know what, it's like a $2,000 difference in a $300,000 thing. But in any event, just tell me which one you concluded was correct.
the number which we pled in our wherefore clause, the 359, 957.
I'm sorry, you're correct. My number was the 361. You now concluded that it's the lower number, which is 359,000 and the rest.
Correct.
Okay. All right. Fair enough. So let me give you a chance to argue anything you'd like before I make a decision.
You know, Judge, there's not really much for me to argue. It sounds like you've covered over everything. You know, we filed our complaint after reviewing the facts of the accident, in which case it looks like we had an uninsured motorist. The conclusion here ultimately is that we believe that our defendant is responsible for those damages, and the total of, after accounting for, as we've outlined, you know, the PIP benefits, the attorney's fees and costs, as well as the money judgment interest, to total to 359, 957.42. And I would be more than happy to answer any questions you have or any concerns, but otherwise I don't think I
do. I mean, my understanding of this is that that your carrier here was assigned under the assigned claims facility.
Correct.
Because it was an uninsured motorist. And As I understand that, I mean, all the carriers get these assignments. I don't know the details of how it works. I don't want to know the details of how it works, but I gather it's, you know, sort of a rotation system or whatever it may be. And then, of course, you get to bring, if I get this right, essentially a subrogation claim against the uninsured motorist.
Correct.
That's what's happened here. The uninsured motorist gets defaulted. You're now moving for the entry of the default judgment. And everything, it seems to me, is in order. So I will rule and order that a judgment be entered against Ms. Bartz in the amount of $359,957.42. Mr. Frangeli, did you submit? I've got something marked order here, and I think it does have the correct number.
It should have the correct number on it, Your Honor. I'm looking over. It does have the same number that was on our brief, so that should be the correct number. And,
that's correct. Yeah, so what I'm going to do is I'll sign this order, and then we'll get it back to you, and then you will then also serve Ms. Bartz with the order.
Absolutely, Your Honor.
All right. What's the date? The 14th. It is signed. We will get it to you. Anything else you'd like to bring up while we're here?
No, other than that, I appreciate your phone call and that you are, as I know, as busy as all judges are. They can't quite all dig into the details as far as the other ones, but I appreciate your in-depth look into my pleadings, and I appreciate it for everyone else who's in front of you.
It's fair enough. It's what I get paid to do, but nevertheless, I appreciate you saying that. And so I appreciate the fact that you followed up on what I asked. You got back to me immediately. And, you know, I just want to get it right. You just want to get it right. So,
Correct.
I think we got it right. And have a nice weekend.
Thank you so much. Take care.
Thank you. We may have one more, but we'll get them.
Your Honor, the next case is Main Drive Properties versus City of Lowell. This is case 2107640FH. Please state your appearances for the record.
Good morning, Your Honor. Philip Slott on behalf of Main Drive Properties.
So, Mr. Slott, I hope I wasn't right or wrong. I'm not sure. Have I met you before?
You know, I think that you swore me in 10 years ago or more.
10 years ago.
Yeah. And I do mainly transactional. This is obviously one of these plat vacation cases, so it's essentially uncontested. So this is the only type of litigation.
No, I get that. Anyway, it's nice to see you again. So this is sort of similar to the last one. It's got a little bit of a different twist. So this is the plaintiff's motion for the entry of default judgment and a consent judgment, which makes it a little bit different than the last one. I also, of course, looked through the very same file that I did in the last one. It does appear to me as if defaults were entered in this case, that no motions to set aside the defaults have been filed. It also looks to me like the non-defaulted parties in the case are Consumers Energy, the City of Lowell, and some state defendants. Am I right so far?
That's correct, Your Honor. We have the City of Lowell, Consumers Power, and then the parties that are represented by the Attorney General's office.
That's right. And I understand, and I think I saw that those defendants, Consumers, Lowell, and the state defendants, have in fact stipulated to the entry of the consent judgment in this case. Is that correct?
That's correct, Your Honor. We had a lot of back and forth with Lansing and OLSR to make sure that we arrived at a consent judgment that satisfies
fair enough.
Amendment process.
So that one is really not much an issue. I'm not suggesting either of these are at issue because it looks to me like you've done these correctly, except that you misspelled judgments. But I'm going to let you off on that.
Well,
you put the E in. Remember in the law, it's the only time the judgment is spelled without the E. But anyway,
that's the perils of all caps, isn't it?
I get that. I really do. Let me see what I got here. So did you send me proposed orders?
I did, Your Honor. I submitted a judge's copy of the proposed order, and I also sent a courtesy copy by email to Deb this morning. I realize there's a lot of paper there. That's what the Attorney General wanted, all these attachments to this judgment.
And there is a lot of paper here. Let me turn to Deb. Do we have those nearby?
It's in there. It's 35 pages if I had to print it out. Is it 34 or 35 pages, the judgment?
You're right around there. I see the 34, 35. Let me look at my email.
I can
Oh,
take that.
okay. I now may see this. So I've got the consent judgment. The consent judgment itself, the order is essentially what, 2 pages? And then there's the consent judgment of vacation. Is that correct?
Your Honor, the default judgment is 5 pages, and it ends with an exhibit list identifying the defaulted parties. And then the consent judgment is 29 pages total.
And that's because it has attachments.
That's correct. It has various recorded documents and surveys and plat amendments.
He can help me out. It's too much paper. I'm going to ask Deb to help me out and get these in front of me.
Understood, Your Honor.
I did review all of this at one point, but I want to spend the time right now.
Yeah, it's been challenging with 40 defendants getting everybody consented.
Trust me, I get more of these kinds of cases than I ever thought I would get. This is, plats and, and all of this kind of stuff where you have all of these defendants. And I guess when I became a civil criminal judge, I didn't know that I'd see these as often as I do, but I do see a lot of these now. Is this a significant portion of your practice?
I just happen to have a few of them right now. I don't know why they all came in at the same time. So.
Okay.
Here's the signature.
All I can say is probably not a bad client because they probably pay your bills.
That's the nice thing about real estate clients.
Yeah. Okay, so I'm sign this one. So I'm signing the consent judgment. And are these the attachments to go with this one?
These are all the attachments.
Okay.
And then there should be another judgment.
So
Is
this copy? This, the other thing should be a default judgment.
I'm looking for it.
Okay. I really do appreciate your patience, folks, but you can see I'm not sipping coffee in the back at least. I'm working. Stefan, I haven't seen you in a long time. Nice to see you.
You as well.
Mr. Slack, can you email just the default judgment? Please?
Yeah.
Thank you. I'll go to this now.
Are there attachments to the default judgment as well?
Pardon me, Your Honor?
Are there attachments to the default judgment as well?
It's just a list of the defaulted parties. There's an
Yeah.
exhibit A, and it just has a list of different defendants that are.
Yeah, okay. I'm ringing a bell with me. So it should just be a list of all of the defendants, and there are 30 of them or 35. I don't know what they're.
Well, Your Honor, I had most of them consented. So
So that means that the list is only going to be those who did not?
That's correct. So if I had 40 people, 25 of them consented, 5 of them made appearances and signed the consent judgment, and this remainder that I'm going to send Deb and Catherine right now need to be defaulted. And that is the defendants.
Right.
There's 9 of them.
Anything to go with default.
I hate to do this to you, but I'm going to ask if you could send the default judgment again with the attachment.
I just did, Your Honor,
Oh,
today.
oh, did you? Okay,
Yes.
okay. Let's see if it arrived.
Yeah, because otherwise you're not going to have for the record the list of the parties that were defaulted and the record will be incomplete. So
Yep, got to get that done. You too, Mr. Slot, have been very patient this morning, which I appreciate.
I'm always shocked at these hearings about the things of the law that I've never heard of, like no fault nuances, and very glad that I don't have to learn about those.
I spend a healthy portion of my job these days doing no fault in the civil arena, and I've got a ton, of course, of criminal stuff. And we had a bunch of criminal motions, and I usually do have a bunch of criminal motions on Friday morning. And then I don't know if you were listening to this, but I had a bunch of motions on a case in which we're trying on Monday morning. So, you know, that stuff has to be decided. So I'm an old public defender. I mean, I did that for a long time. So I have background in criminal work, but being a judge is different than being an advocate. So.
We're running it files to the next.
Thanks. All right, so I'm now going to sign the default judgment, which is 4 pages long. And then I have a 5th page that says defaulted defendants, and there are 9 of them. Is that correct?
That's correct, Your Honor. It begins
All
with
right.
Corbin, ends with New Residential Mortgage LLC.
You got it. So I now think I have what I need. I'm going to sign and date this. Do you want us to put these in the mail? Do you want us to email them? Do you want us to do both?
I don't need anything, Your Honor, because I need certified copies of them. So what I'm going to do is just wait them to get down to the clerk's office, and then I'll order the certified copies for recording.
Oh, okay, fair enough. So is there anything else then, Mr. Slot?
No, Your Honor, this should wrap this up. I really appreciate your help, and good luck with the rest of your docket hearing, okay?
Thank you, and again, thank you for your patience.
Thanks, sir.
Now we move on.
You call that one, Your Honor?
I will
Do
call
you want
this.
to have certain people come up to the?
Well, yeah, let me call the case, and then for those who are directly involved in the case, if you could come up to the tables, that would be great, and then we can go from there. So this is in the matter of Joseph Juanito Orcasitas Reyna and Betsy Diaz Reyna. This is essentially, I guess, what I'll call sort of a status conference about how things have been going. This has been a very contentious case for a long time. I'm hoping it's a little less contentious these days, but it is what it is. And, you know, I mean, I've got grandparents who love these kids, and, you know, so that's often what results. It's some contentiousness. But in any event, do I have people involved that would like to come up to the table? Why don't you come on up? And I believe that I recognize both of you ladies.
Your Honor, it's Ms. Newhouse.
Oh, Ms. Newhouse, good morning to you.
Good morning, Your Honor.
So Ms. Newhouse was involved in this case, I think, I don't know, starting the last hearing, but she was certainly involved in the last hearing. And then I did get an appearance by Mr. Stefan. And he is now representing Gabriela Reyna Torero.
Correct, Your Honor.
All right. So let me tell you what I've received in the case so that everybody knows what I've got in front of me. I received an annual review report from the Department of Health and Human Services, which I received on October 14th of 2022. Although it's actually stamped September 20, but we didn't get it until October 14. Oh, no, you know what? I apologize. 14th is actually the date of the hearing. So we got this, I guess, on September 20th, maybe 3 weeks ago. The department always tells us, you're really not supposed to distribute this stuff and et cetera, et cetera. But I also like people having in front of them what we have. And so I'm certainly willing to make copies, and we can email one to Ms. Newhouse, and we can give you a copy, Mr. Stebbins, so that you see what I got. So I do have that. And then I also received a CASA report, which is dated the 10th. So I guess that was actually maybe this past Monday of this week. So those are the things that I've received. I'm not going to sort of belabor the point, because it has been a long, and I mean, I don't mean this pejoratively, but it has been a contentious matter. And so at the last hearing, I believe that, and Ms. Newhouse, I want to have you make sure that I remember this right. At the last hearing, I believe that I did grant a guardianship. I want to get this right. To Ms. Leonard, is that correct?
Your Honor, she's had guardianship for some time.
Yeah, okay. But then what happened at the last hearing is that I also ended up giving some limited grandparent time to, and again, so much stuff on I'm in front of me. Your client is Ms. Torero, is that correct?
Yes, Your Honor.
Yeah, okay. And it was limited time, and as I recall, it was also supervised time, and there was I think she was a close friend. She testified at the last hearing. I think she was a close friend of Ms. Ferrer, as I recall. And she testified, and then when she was testifying, or maybe after she was off the stand, I asked whether she would agree to be a supervisor, and she did.
That would be Janet Vargas. Your
I
Honor.
think that is correct. I think that's the lady that we're talking about. And again, I mean, I'm just swamped. And so I'm sorry I couldn't spend a little more time on this, but my recollection is that it was going to be limited grandparenting time. Seems like maybe it was going to be like Saturday or something like that. Am I close about that? Because at the last hearing, there had sort of been this issue about an injury to the child, which was never substantiated by CPS. But I mean, I heard a lot of testimony about that. And so we were going to see how that went. And so that's, I think, really sort of what today's hearing is. Now, I did at least have a chance to read what I've already indicated. And Ms. Newhouse, do you have a copy of either or the CASA and the department's reports?
Yeah, I have the CASA. I don't get the
Right.
DHS report, but I have the order. The grandparenting time was both children every Sunday from noon until 4 p.m. supervised by Jeanette Vargas.
Yeah, so it was Saturday. I mean, it was Sunday, not Saturday.
Mm-hmm.
Yeah, okay. And so again, this is just sort of a how's it going and how has it been going kind of hearing. I think I read that the supervisor opted out at some point. I don't remember when that was. Who can give me that time frame?
July 10th.
July 10th?
Yeah.
Your Honor, the last hearing, I believe, was in August. So if she was appointed in August, she wouldn't have opted out in July. Or was that when this was last set?
Yeah, I mean, I don't think we went
Just the 2 months?
Yeah,
Okay.
yeah, we didn't go just the 2 months. It was a while ago. But in any event, so I guess what I'm going to do is what I would normally do, and that is that I'm going to ask if both of you ladies would please raise your right hand whenever she's done.
I need a translator, Your Honor. That's what she's here.
Got it. So, well, why don't I include the translator in this? Ma'am, our interpreter, could you give us your name, please?
Yesenia Reina.
Thank you. And now I must swear you in. I wonder if I could ask you to please raise your right hand. First, the interpreter. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications?
Yes, I do.
Thank you. And I'm presuming that the language is Spanish and English.
Correct.
Fair enough. So you can put your hand down. Thank you. Now, I will ask the two ladies to please raise their right hand. I'll go through this a little more slowly so it can be interpreted. Do each of you solemnly swear or affirm that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
Okay.
Okay, thank you. You can put your hands down. I guess let me start. I know you're sort of new to the case, Mr. Stefan, but why don't you sort of tell me the position that your client is taking? Also, if she has an explanation, maybe she doesn't, about the lady that was going to help supervise, why she's no longer doing that. I mean, I just want to kind of get caught up on this stuff.
I appreciate that, Your Honor. And after reviewing the file and everything, I do kind of feel like I'm jumping into a hornet's nest.
Well, I mean, it's been a difficult case, but I think I thought maybe, maybe in time it's gotten a little less contentious, but I mean, it has been a difficult case.
Yes, Your Honor. And so the court is aware. We do have Miss Janet Vargas here present in the courtroom.
Oh, I'm sorry, ma'am. I didn't see you way in the back.
She is willing to testify as to why she was no longer willing to be the supervisor. But the short summary of that is that Ms. Reinhardt had made some threats to her regarding her employment. Ms. Vargas she's been employed at Head Start for 20 years. She's a mandated reporter. With some of the threats that Ms. Leonard was making, one in particular, she had apparently told her that she was going to report her for kidnapping the children at one point. She was afraid she would lose her job. And so she just wasn't willing to stay on given that information.
Put her on the stand.
Ms. Vargas?
Again, welcome back to you. You may recall this, you're gonna end up in that seat, but and as I recall, you're bilingual.
Yes.
Okay, so I wonder if I could ask you to please raise your right hand.
Do you want me to stand up?
We'll do this, then you can answer. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Please.
Thank you.
Mr. Stefan, even though I asked you to put her on the stand, I'm going to ask you to do the interrogation.
Yes, Your Honor. Thank you. Ms. Vargas, how are you today?
Good.
You were previously appointed to be the supervisor for Ms. Ferrero in her parenting time.
Yes.
How long did you act in that capacity?
The last time I did the supervised visitation was on July 10th. That was the last time.
During the time that you were supervising, did you ever see anything with Ms. Ferrero and the children that gave you concern?
No.
And if you would kindly state for the court where you're currently employed?
It's Intertribal Council of Michigan. It's a Native American Head Start. Yes.
Are you a mandated reporter at that?
I am.
How long have you been there?
November 3rd is going to be 20 years there.
During your time supervising the children, did you have frequent encounters with Ms. Leonard?
Yes. Pick up and drop off.
How did those?
I'm sorry, I missed that.
In the pickup and drop off.
In the pickup and drop off.
Yes.
Okay.
So did you provide transportation for the children?
I did.
Can you describe how those interactions typically went?
It all depends on Miss Leonard's day, how she was feeling. Sometimes they were good, sometimes they were bad. It was never the same.
Why specifically did you stop acting as the supervisor?
I really like my job. I really like working with kids. I don't do it for the money. I do it because I need, I want to help kids. So I did not want to lose my job over something that Ms. Lenards would say or do. So,
What led you to believe Ms. Lenards was going to say or do something?
she has done that to Gabriela. That's why they appointed supervised visitations, because she accused her of hitting her
Right now,
grandkids. Oh,
I know
sorry.
that history. Let's keep us focused on the contact
Sorry.
you have had with Ms. Leonard's that led you to resign from being the supervisor.
Basically, I didn't want the same thing that happened to her to me, if that makes sense.
Well, it makes sense, but were there specific incidents or threats or anything else? Or was it just you didn't trust her that she might not do to you what you believed she had done to Mr. Herrera?
Like there's texts that she wrote to me, and also she would accuse me of interrogating her grandkids, and it's not interrogating, or I just ask if they ate, if how much, because depending on how much they eat, Miss Gabriela would make either breakfast or just a snack, and she would take it the wrong way and say, "You are asking too many questions," and she would tell me, I don't want you to interrogate my kids and things like that.
You were present in the courtroom when I made this statement. Did Ms. Lenards ever accuse you of trying to kidnap the children?
Yes.
Can you elaborate on that?
Gabriela had a vacation that she was planning to take the kids. Over 2 years, she was paying for these vacations. And I believe she asked her if she could take them. She said no. Ms. Leonard said no. So Gabriela went to these vacations on her own with her husband. That Sunday, Ms. Gabriela asked me if I would pick up the kids, take them out to Chuck E. Cheese so she could have a visitation through the phone, through Zoom or through video. And I said, yes, I would do that for them. And I took the kids to Chuck E. Cheese. They talked to Gabriela. They had a good time. They spent time with her over the phone. And I also took my son, and he's 7-year-old, and later on took them back to the house. She was fine. Ms. Lenards was fine. There was no problems until maybe 2 weeks later. Then she remembers that I took them to Chuck E. Cheese and was upset, and then didn't allow me to pick up the kids anymore when it would change.
So at that point, she would no longer allow you to provide transportation for the children?
Yes.
And what did she say to you that let you know she was upset about you taking the children to Chuck E. Cheese?
She said that I did not have visitation rights, that I was not supposed to do any visitation rights, that I was not supposed to pick up the kids.
You mentioned that you did this so Gabriela could FaceTime or Zoom with the children. During your period observing her, doing her parenting time, was she allowed to do phone calls with the children when they were with Miss Lenards?
No.
So was this her only way of being able to see the children during
Yes.
that time?
Yes, because that was her visitation time.
Were there any other specific statements made by Miss Lenards that caused you to be afraid that you would lose your job or that your employment could be in jeopardy?
There's not a lot of communication. I tried to communicate with her, specifically of Joseph there was an incident with the sword. I was trying to communicate with her, but I was told that she was in the bathroom and then later told that she was in Las Vegas. And then I just wanted to have communication with her to let her know what happened with the child.
You said there was an incident with the sword. When did that occur?
I believe that was on July 10th.
What happened?
We went to the store and Joseph was being sneaky. He when I purchased my things, he put that sword in my bag, so they got ringed. And we told him that that's not something we do, that you needed to ask permission, and that Gabriela had said no to that sword because she didn't want him to hit Betsy with it, and that that what was done, but it was going to stay in Gabriela's house so she could supervise him, watch him, that he wouldn't hit Betsy with it. So we agreed on that. And when we went to drop them off, he grabbed the sword and he ran into the apartment. So then I talked to Jesse, and Jesse made Joseph come upstairs, give me the sword. And Joseph said, you're hurting me. And I was like, I'm not doing this. I'll let Dad take care of it. I'll let Dad take, action. And he took it and never had any problems with Jesse. He's very nice person. And I just didn't want to be accused of hurting him. And I tried to talk to Ms. Lenards, but she told me she was with her mother, that her mother was very sick and ill. So then I said, we will talk about this in another occasion. I understand if your mom is in the hospital, this is not something you want to talk, it's okay. But later found out that she wasn't in the hospital with her mom, that she was in Las Vegas. And that kind of upset me, or because I was lied to. And I really wanted to communicate with her. I really just wanted to tell her what was going on. That's it.
So, and you are going to remain silent during this testimony, aren't you? Aren't you? Thank you.
What did you view your role as the supervisor for this parenting time?
Can you repeat that again? Sorry.
You indicated you were trying to talk to Ms. Lenards as well. What did you view? You were appointed as supervisor for Ms. Guerrero's parenting time. What did you view that role to mean? What did you think you needed to do in that role?
Supervise that the kids were safe and they were taken care of, and really wanted them to have more communication. I think it's very important for them to have communication, because the kids are very smart and they need that. They need to know that they are both are in communication. And that's
If the court were to ask again, would you be willing to act as supervisor again?
only if they would give me a camera like the police would carry, because I would feel safe. I don't feel safe that she usually says, Ms. Lenards usually will say that I did something, or that I'm interrogating the kids, or that I'm not doing the best for the best interest of the kids. So I'm kind of worried about that they will believe her versus me. So I would only do it if I had maybe what the police officers wear, a body cam. So you guys could see both sides, because so that way you could see how she acts with the kids, and how she plays with the kids, and how she acts with the grown-ups or the kids.
Just in last little bit of follow-up, you were also able to somewhat observe Ms. Lenards' interactions with the children.
Yes.
Did any of her interactions with the children give you concern?
Yes. There was a time that I needed to talk to her, and I just wanted to talk to her about something that had happened with the kids. She started yelling in front of the kids, And I needed to stop and immediately leave that situation.
Did you ever have any concerns on how she interacted with the children directly?
Yelling, just yelling.
Any concerns with her supervision of the children?
Yes, Joseph says that he's allowed to be in the woods anytime he wants,
I'm sorry, Joseph said what?
that he's allowed to be in the woods anytime that he wants. Yeah, there's
Got
like
it,
little
got it.
woods.
Okay.
Betsy says that she's not allowed to go to the living room because that's Joseph's bedroom. And she has to be in her room all the time.
I have nothing further at this time, Your Honor.
Ms. Newhouse.
Thank you. Ma'am, you were only hired as a supervisor. You weren't hired as a worker on this case. Is that correct?
Correct. Volunteered, not hired.
Okay. Yeah, you're right. Isn't it true that at the very first visit that occurred on March 22, either you and or Ms. Reina Torero called the police?
It did happen. I don't know if it happened that day, but it did happen when we went and pick up the kids and she wouldn't let Gabriela take the kids. So then we would have to call the police for the police to document that stuff.
So you're alleging that she didn't allow the visits to happen?
That's the only reason we would call the police, to report or to document not being able to pick up the kids.
Okay, and how many times did that happen in your?
It happened a few times, maybe 2 times. One time Gabriela was hurt. She had a burn in her hand from her work and she couldn't drive because she took a pill. So for pain, and she asked me if I would go and pick up the kids. I said, yes, I would pick up the kids, go to her house, play in her house or stay in her house. And Ms. Leonard said, no, if Gabriela's not in the car, I don't want you to take them. So we had to call the police and, just to report for her evidence or that the kids were denied visitation time. That was the only reason.
How many times did you end up calling the police on Ms. Leonard's since March?
I believe 2 times, but I could be wrong.
Could be more?
Yes.
And what about Children's Protective Services? How many times did you call them regarding the children and Ms. Leonard since we were last in court on March 22nd?
I believe I have only done that once or twice.
Do you understand how that might be frustrating and might anger Ms. Leonard's?
Yes, it can.
And then that visit that when you came to get the kids on May 15, the one where you take them off on your own and you go to Chuck E. Cheese, you didn't tell Ms. Leonard's that Ms. Reina Torero wasn't going to be there, did you?
It was my understanding that I was supervising and that I'm not so, they need to communicate, they need to talk, and they need to be able to talk about that stuff. I'm just there to supervise and make sure the kids have a good time and be able to Reina have communication with her kids, grandkids.
You didn't think to tell Ms. Leonard's, hey, Ms. Reina Torero is not going to be with us. We're going to Chuck E. Cheese with my grandson and going to have a good time. And maybe they'll talk to Ms. Reina Torero on the phone quick. You never thought to tell Ms. Leonard's that?
Sometimes the less words I have with Miss Leonard, the better, because she sometimes likes to fight with me. So now that you say that, maybe it should have been the more appropriate thing to do, but I did not do that. And I'm sorry for that.
Well, she was upset that you had the children and the children came home and reported to her that their grandmother wasn't even at the visit. Does that sound about right?
She was not physically there, but she was in the phone, by video camera all the time,
All the time, the whole time you were at Chuck E. Cheese, she was,
most of the time.
so
Most
the
of the
kids were in
time.
front of a phone and not playing at Chuck E. Cheese and running around, right?
Most of the time, most of the time.
Okay, do you
When they
understand
were
how?
eating, when they were playing, there was videos sent to her. There was things. I had a little video phone. I had the phone with me showing them, look, they're playing. This is what they're doing. They're talking. After the Chuck E. Cheese, we even went to see pets. We went to see dogs. We went to see spiders because that's what the kids wanted to see. They talked to Miss Gabriela and talked about getting a pet, talked about spiders. So they had my phone and that's what they were doing.
And you thought that was consistent with the court's order?
The kids
does
look,
it?
yes,
Excuse me, let her finish, please. What were you
I
saying?
apologize.
the kids look forward to Sunday's visits. They look forward to seeing me talking, having some attention and doing things that they like. So yes, I did think about them. That was Mother's Day weekend. I left my 5 kids, did not go out to eat with them so I could do this for those kids. I hadn't seen my daughter. She serves in the Army. She's a medic. And I really wanted to see her that weekend, but I asked her if it was okay if I come and take some time with these 2 kids that needed some love and attention and just to distract them from all this chaos. Just wanted them to have a good time.
Thank you. Nothing further.
Mr. Stefan, any redirect?
Yes, Your Honor, I just want to clarify. You admitted to calling CPS on Miss Lenartz.
Yes,
Through your work, are you a mandated reporter?
yes, yes.
I have nothing further, Your Honor.
Well, let me follow up on that. What caused you to call CPS?
I'm concerned, sometimes, first of all, not being supervised. Joseph needs to be supervised. It worried me that he was gonna be out in the woods and it was raining. And my concern is there's older kids there that are 14 or older than him. And I'm afraid, that could get him into trouble. Or Joseph had talked to me about they were in war with the kids and they have it's probably a game they're playing. But I don't feel comfortable leaving Joseph alone in the woods, especially if he tells me that he walks to places. So it
How old
just,
is Joseph?
he is 10 years old.
Okay.
Yes. I wouldn't leave my son like that, so I just concerned and just wanted somebody to check on him.
Your Honor, if I may follow up on the question about his age. Is Joseph also special needs?
He has autism, so that's one of the reasons I worried. Yeah.
Thank you for your leeway, Your Honor.
I give you recross on those questions.
No, Your Honor.
No, to Ms. Newhouse.
Yeah, I have a question. Do you know what the result was regarding that CPS investigation?
They just said that they would investigate and that's it. They didn't let me know anything else.
Okay. You're not aware that it was substantiated or that it went any further?
No.
Okay, thank you. Nothing further.
Ma'am, do you have any suggestions or ideas about who could presume the role that you were playing? So that my order that permitted the other grandmother to see these children could be fulfilled.
I know that there's agencies that would do that. They told Gabriela that there's an agency where at the gym where she could go and get supervised visitations there. She tried to do that, but it never went through. I don't know why.
You know whether that cost money or whether it was.
She is willing to pay. I think it was $50. She's willing to pay. She
So
just
your
wants to.
understanding is that she would be willing.
Yes.
Follow-ups to my 2 questions or 1 question?
No, you're not.
All right. Thank you very much.
Thank you.
Appreciate you coming in. Appreciate you testifying.
Oh, yes, thank you.
I wanted to hear from her because first of all, she may want to get out of here, but Ms. Newhouse, do you want to present any evidence today?
Yes, I'd like to briefly call my client,
All right.
Sherry Leonards, please.
Fair enough. Ms. Leonard, if you could please come up. Please raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Go ahead. Have a seat, please.
Thank you.
Go ahead, Ms. Newhouse.
Thank you. Could you please state your name for the record?
Sherry Lynn Lenartz.
And Ms. Leonards, you're the paternal grandmother of the children and the guardian?
Yes, that's correct.
Okay, can you tell us visitation, the first visit, it sounds like was March 22 following the court's order?
That is correct.
Okay, how did that visit go?
I think the visit went okay. But when the kids were brought back home, the police showed up 10 minutes later.
I'm sorry, I didn't hear that.
When the kids were
brought back home.
When the kids were brought back home from the first visit, the police showed up at my home about 10 or 15 minutes after they were dropped off.
Okay.
And they asked where Joseph was at, and Joseph was in the living room playing his game. And they said they had a report from Janet and Gabriella that Joseph was in the woods, that he ran to the woods after the visit and that he was unattended and this and that. And so that wasn't substantiated. That was a lie. And Joseph was safe in the house and was just
Was
playing his
CPS
games.
involved? I'm sorry, was CPS involved in that or just the police?
Just the police on that occasion.
Okay, and then from that occasion forward, did you have any other interaction with the police?
There was one visit where she mentioned that her arm was bad.
You gotta say.
Gabriella's arm was hurt or something from work and could not attend the visit. So Janet was over at her house and they called the police to let them know that. That wasn't an occurrence, so, okay.
Did you allow the children to go on a visit that day?
I didn't know. I didn't know until after the fact.
Oh, so the kids did go on a visit that day?
Yes, yes, they did.
Okay, and then have you had CPS interactions since March?
Yes, I have. Again, it's my 9th time. And I'm very, very frustrated with this when there's nothing going on with the children. The children are safe. They are fed. They are educated. They are taught manners. They are in a good routine home. I don't know what she has.
You just answer the question.
Yeah, okay, I'm sorry.
Okay.
Okay, yeah.
Was there an incident on May 15 where the children were picked up by, let's see, I don't want to mess up her, Janet Vargas?
Yes, that's correct, Chris.
What was your understanding of what that visit was going to look like?
Well, I just was under the understanding because Janet would come to the door and say, hey, I'm here for the kids. And we would exchange them. I would, the kids would go upstairs and I just figured that she was there on a normal visit and getting the children, for Gabriella, who was usually out in the vehicle, I guess. But Gabriella wasn't present and I didn't know that. And she took the kids and I just think that okay, she took the kids without Gabriella being with her on that day, on that Sunday.
Was that upsetting to you?
It was, because I think I should have been like at least told or even asked, you know, if that was okay, because the visits are set for the grandmother, they're not for her. I mean, she's a supervisor. And
Did you use the word kidnapping to her?
I just said that because she said that I shouldn't be making a big deal about it. And I said, well, in all reality, if you want to be technical, that is like, I said, it's like kidnapping. I didn't accuse her or threaten her or anything like that. And I have the text messages from that. I wouldn't accuse her of that, but I just said, in all reality, that's what it was. I wasn't told or anything. I'm the guardian. I should know these things.
When was the last visit that, well, okay, so from July 10, it sounds like, through September 15, there weren't any visits? Is that right?
No, she never called me. She never called me for 8 weeks. And then she had called on a Thursday in September, mid-September, and asked to talk to the kids. And I said, of course, sure. And
Once again, who's she?
I'm sorry, Gabriella.
Okay.
Gabriella, she talked to the children. It was like after school on a Thursday. I remember it was a Thursday. And she wanted to see the children, and she asked me if she could take them to, you know, like Craig's Cruisers or something on her own. And I said, no, I'm not going to do that. I'm not going to break the court order, and I don't feel comfortable doing that. So she kind of asked if she could see them. And we set up a time for the following week to meet at the park, which I went down in my car and brought the children down there so that they could see her and have some time with her, you know, and I supervised it. And yeah, and that's what happened.
Okay.
Yeah.
So you facilitated that?
Correct.
visit. Did the children have a good time?
They seem to have a good time, yeah. I
Okay.
hadn't seen her for a couple months, you know, and so yeah, they seem to be okay.
What's your position, best interest wise, regarding, let's start with Joseph, seeing his maternal grandmother? Are you in favor of that? What should that look like?
I'm so back and forth with it. I don't like the questioning of, you know, the 4 hours that she receives with Joseph. Shouldn't be asked questions. She shouldn't be, you know, asking about what's going on at home. It should be quality time.
What are we now talking about?
She asked what I thought was the best interest of.
No, I get that, but then you started answering it. There was something about 4 hours or something.
The 4 hours should be spent like quality time, and, you know, not with like questioning and asking questions during that visit time. Like, they shouldn't be asking them questions and interrogating.
Is it your understanding that when she has parenting time, that she has to do what you want her to do?
No, not at all. I just don't think it's fair to the children to have to, I don't think it's healthy for their brains to be asked questions all the time, Your Honor.
Okay.
Okay, and does he, if he said anything, what does he want? Does he want to see his maternal grandmother?
He has said that he wants to see her, and he's talked to other, like Casa and stuff, and he does want to see her for those 4 hours. And I asked him if he wanted to go even a little longer, you know, and he said, no, Grandma, I want to see my grandma for 4 hours still. And that's where we're at with that right now.
Is Joseph age 10 with a diagnosis of autism running around in the woods unsupervised?
No, Joseph has a place, what do you call it? A perimeter behind my home of how far he's allowed to go. And I go back there. If he doesn't check in 20 minutes, I'm right outside calling his name. Joseph, why haven't you checked in? Get in the house now. You didn't follow directions, etc. So he doesn't take off nowhere, and he knows his boundaries. And for having mild autism, he does very well with it. He's never been you know, he does fine in the woods. He's playing with his friends.
And briefly, there was an incident regarding a sword at your house.
Right, that's correct.
Were you there?
No, I wasn't there, but I
Okay,
did
stop
speak to-
then.
Okay.
Stop then, okay?
Okay.
Betsy, how old is Betsy?
Betsy is 7.
Okay, and tell me about Betsy. Does Betsy enjoy these visits with her maternal grandmother?
She says she doesn't want to go. And she still says that to this day. And she says that she'll go if Joseph goes. That's kind of ends up being her final answer. But she's not comfortable going. She doesn't want to go. And she's told other people in authority of that too, like the police, CASA, Travis from Guardianship, etc.
So you're not opposed to the children having supervised parenting, grandparent time with their maternal grandmother. Is that your position?
No, I'm not. That's fine.
And it sounds like the supervisor is no longer willing, Ms. Vargas is no willing to do that. Would you be willing to look at some other supervisor or at a supervising agency?
Yes, there is an agency that will help with this. And they
You
did
would-
contact me very recently.
What
And,
agency specifically?
I can't think of the name. It's 2 words. I just can't think of it right offhand.
Is it Safe Connections?
Yes, it is.
Okay. And you'd be willing to cooperate with an agency such as that?
Yes, most definitely.
Okay, and you continue to cooperate with CASA?
Yes, I do cooperate with CASA. Yes.
How often do they see the children?
She's taken them a couple times and talked to them on their own and took them like to the museum and things. And I've talked to her, 3 or 4 times regarding how things were going for the children and so on and so forth. So that they're still involved.
Great, thank you. Nothing further.
Okay.
Mr. Steffen.
Thank you, Your Honor. Ms. Leonards, do you still believe supervision is necessary for Ms. Ferrero's parenting time?
Like I said, I'm back and forth with it. You know what I mean? There wasn't a lot of time spent with supervision because of Janet not doing it very much, anymore. So
Was
yeah.
your understanding the supervision was put in place because of a pending CPS investigation?
That a couple of reasons why, yes.
And were you aware of the end results of that CPS?
Yeah, we already all know the ending results. That's correct.
We established CPS did not substantiate at the last hearing.
I was just clarifying that given
That's
that they
fine,
did
I
not.
just want to let you know that had been established, but go ahead.
I appreciate that, Your Honor. Given that CPS did not substantiate, why do you still believe it is necessary for my client to have supervised?
It's very easy to answer. Betsy does not want to go. There's a reason why she doesn't want to go. So that is why I think it needs to be supervised still until she feels more comfortable. These are children, so.
You asked, or I'm sorry, you testified just a little bit ago that you thought during the 4 hours of time that my client gets, she shouldn't be asking the children any questions about what's going on in your home.
That's correct.
When the children come back to you, do you ask them questions about how the parenting time went?
I asked them how their time was. Sure, I do. Everything go okay and just make sure everything went okay.
Do you believe it's reasonable to ask the children how things are going in either home?
Well, yeah, they can ask shit. That's reasonable if that's what it was.
Do you have any reason to believe that's not what it was?
From the past, I believe it could be more, and the kids do state more things, which doesn't need to, it doesn't need to be done every time.
You testified you were not there at the home for the sword incident.
That is correct.
Where were you?
I was in Las Vegas on my yearly vacation.
You heard the testimony saying that you spoke to Ms. Vargas
I did speak to Ms. Vargas towards the end of that.
and that you told her you were with your mother.
No, I said my mother was in the hospital. I didn't say I was with my mother.
Did you
And I-
tell her at that time you were in Las Vegas?
Yes, I did. I don't need to tell anybody where I'm
Right
at.
now, ma'am, you answer the question.
Right.
You don't make speeches. Thank you.
Okay, Your Honor.
Since May of last year, have you witnessed any parenting time besides the September incident with my client and the children
Since May of last year?
since May of this year when this order was put into
Okay.
place. Have you witnessed?
No, I have not.
And on that September date that you took the children to the park, did you witness any inappropriate behavior between my client and the children?
No, I did not.
I have nothing further, Your Honor.
Redirect, Ms. Newhouse?
No, thank you.
All right. Thank you very much. You can step down.
Thank you.
Any additional evidence, Ms. Newhouse?
No, Your Honor.
Mr. Stefan, did you want to present any evidence today?
Yes, Your Honor. Although if I may, the court had suggested that it may be willing to allow us to see the CASA report.
Yeah,
for the
but
DHS.
it sounds to me like Ms. Newhouse may have seen the CASA report, but maybe not the DHHS report. Can I ask you to make copies of these? And Ms. Newhouse will email you the DHHS report. We'll make you copies of both.
Thank
Did you have the CASA report?
I don't have.
Okay, all right, so we'll make you a copy of that.
Your Honor, if I could ask for just a brief recess to actually see the report before I get my client on the stand.
I'll give you that. I have been on the bench since 8 o'clock this morning without any kind of a break. I want to get this hearing finished, but I also want to give everyone a chance to be heard. So it will be a brief break.
Yes, Your Honor, I just,
Fair enough. Thank you.
I don't want to walk into a question that's
I
already
get,
been
I get
answered.
it. It's only fair. I mean, I think you're entitled to review the report. I think you both are. I said that earlier, and I think I just forgot to ask Deb to actually make copies and get it to you. So we're doing that now.
Thank you, Your Honor.
And if you see anything, Ms. Newhouse, that you weren't aware of, I'll give you a chance to
I
ask
just,
me.
are we gonna put these in as exhibits or don't we do that on these minor
Well,
guardian?
as a general rule, the department doesn't like us to make things as exhibits, but the CASA report, I don't have any particular feelings about that. I mean, I'm the one who appointed CASA, but these cases are in between cases. They're not abuse and neglect cases. They're not custody and parenting time cases. And the department is territorial about these investigative reports that used to be called home studies. Now they're called investigative reports, and we ask them, are we able to share these? And their usual answer is you can share them during the hearing, but we don't want you to distribute copies. But I'm making an exception to that because in part Ms. Newhouse is not here. I want to be fair about that.
Okay, thank you.
You're welcome. As soon as she gets back, I'll find it. Do you know, Ms. Newhouse, whether Deb has your email address?
She does, because I requested that report about an hour ago.
Well, there you go. Well, she's been here sitting next to me, so.
Hour and a half. Maybe I sent it to Kathy. I'll send it to Deb. Yeah.
Yeah, Kathy's not in today.
Okay.
So, but again, I mean, I think she's copying it right now, so.
Okay. I'll get her my email.
Deb, do you have Ms. Newhouse's email address?
I'll scan this for momentarily.
Did you scan it?
I scanned it. and
Okay.
sent it to her. Yes.
You should be getting it at any time, Ms. Newhouse.
Got it.
Good.
Thank you.
Yeah, folks in the back, I wanted to make sure that we didn't have a separate hearing with you folks because you've been here a long time too. But I gather you're just here spectating?
Yeah,
It's a public courtroom. Anybody can always watch. I just wanted to make sure that I wasn't keeping you even longer. So thank you.
Your Honor, thank you for that
You're welcome.
brief period. At this time, I would like to call my client, Ms. Reina Torres.
All right. And I don't want to force the interpreter to stand. That'd be great. Thanks.
Second.
I remember, did I already put these folks under oath?
Yes, you placed everyone under. oath.
That's what I thought. I know you know this, but I always remind people with the interpretation, you may have to take pauses.
Yes, Your Honor.
Thanks. Well, sometimes it's simultaneous and sometimes, they need a chance to interpret.
Like you in your former life, I come from the criminal world as well.
Yeah, there you
We
go.
do a lot of this.
Exactly right.
Ms. Reina Torres,
Señora Reina Torrero.
when is the last time you got to see your grandchildren?
¿Cuándo fue la última vez que usted miró a sus nietos?
Fue en la fecha que dijo Janet.
No sé. The last time she see her grandkids was the date that Janet mentioned.
That was the day in September.
Yes.
La fecha de septiembre?
Ujú.
Yes.
How did your time with them go at that time?
¿Cómo fue su tiempo con ellos en ese tiempo?
El tiempo que pasábamos era pues muy divertido porque ellos estaban contentos, Betsy feliz por verme.
She said the times that she seen them, the kids were very happy, very excited to spend time with them. Betsy was very happy and excited to spend time with her and see her.
A veces sí me daba tristeza porque ella empezaba a contar los minutos porque dice que ya se tenía que regresar y no quería.
She saying that Betsy sometimes would mention that it was time for her to go home and it would make her sad because she would count how many minutes were left for her to go home and that she did not want to go home.
Prior to July, when Ms. Vargas stopped as the supervisor,
De ser supervisora.
did you exercise your parenting time every time you were given the opportunity?
Usted usó cada oportunidad que tuvo para ver a los niños, la usó.
Sí, de hecho yo traté de hablar las llamadas de ella y textos, pero ella me laqueó.
She says, yes, she did, and that she would try and communicate with Ms. Lenartz, but Ms. Lenartz blocked her from calling and texting.
Are you able to communicate with the children directly when they're with Miss Lenartz?
¿Usted tiene oportunidad de comunicarse directamente con los niños cuando están con la señora Lenartz?
No puedo comunicarme con ellos.
No, I cannot communicate with them.
Do you have any phone calls with them when they're with Miss Lenartz?
¿Tiene alguna llamada con ellos en el tiempo que ellos están con la señora Lenartz?
Como una llamada.
Que usted llame, hable con ellos.
¿Por teléfono? No, nunca pude hacer, nunca me dejó.
No, I wasn't able to. She didn't allow it.
When you were exercising your parenting time, what sort of things would you do with the children?
Cuando usted usaba el tiempo de ver a los niños, ¿qué clase de actividades hacían?
Cuando estábamos con Janet,
Sí.
las actividades pues era pues llevarlos a la tienda, estábamos en la casa, jugábamos en el jumpy. Eran muy poquitas horas, no era demasiado para poder compartir con ellos.
She saying that when they did spend time together, they would be at her house, jumping on the trampoline. They would go to the store. They would play. The 4 hours were very limited for them to spend time together, but she tried to do the most out of it. Continúe.
Do you feel that your parenting time needs to be supervised still?
¿Usted siente que su tiempo con los niños necesita ser supervisada?
No, no es necesario porque pues todo el tiempo, pues ahora sí que han pasado muchas cosas y yo no necesito ser supervisada. En primera, yo no soy mala, no soy de las que las ando interrogando, eso es mentira. No es tampoco de que Betsy no se quiere ir conmigo, eso es mentira porque a veces no se quiere regresar.
I don't feel like I need to be supervised. I'm not a bad person. I don't mean no harm. I think that I don't need to be supervised. The kids seem fine. Continúa.
Porque prácticamente pues yo cuando tenía la semana que cuando tuvimos ese tiempo, yo no tuve supervisión, pasó lo de la quemada, sí, pero pues todo el tiempo pues ahora sí que ellos estaban contentos, felices de estar conmigo, quedarse en las noches.
Prior to the supervised visits, I had them week to week. They were fine. No, other than the burn that Betsy had, we were fine with them, no major issues. So I don't believe I need to be supervised.
Not directly a question, but Ms. Torres, if you would pause to allow the translator to catch up, maybe just 2 or 3 sentences at a time.
No fue directamente pregunta, pero que tome unas pocas pausas para que me deje interpretarle así.
Yeah. I have to say this because I know it's just not intentional. You also speak enough English that sometimes you are also speaking in English. I get that, but it gets a little complicated. And in some ways, I almost prefer if you just spoke Spanish and we'd have the interpreter interpret it. Because sometimes it's a little difficult when you're going in and out, which is not a criticism of you, but I just want this to be able to be easily understood. Are you okay with that?
Que sí está bien que lo interprete todo completo.
Thank you.
Gracias.
Thank you. Ms. Reina Torero, if the court, would you be willing to comply with supervision to be able to see the children still?
Si la corte le pone supervisión, ¿usted estaría de acuerdo seguir viendo a los niños?
Está bien, no, así que la decisión la toma el juez. Yo no puedo decidir yo qué más quisiera, que sé que los niños.
Yes, I would agree to it. The decision's up to the judge. The only thing I want is to see the kids.
Have you, besides Safe Connections, have you looked into any other supervising agencies?
Aparte de Safe Connections, ¿ha buscado otra agencia de supervisión?
Sí, yo llegué a buscar una, la que está es YMCA, que estaba en el downtown. Yo metí los papeles, traté de hacer todo. Me dijeron que me iban a cobrar $50. Les dije que está bien.
Yes, I did. I reached out to YMCA and they said yes, that they would take the case. I filled out all the paperwork. They would charge me $50.
Have you contacted Journeys?
I'm sorry, can you repeat that again?
Has she contacted the agency known as Journeys?
Que si ha tratado de contactar a la agencia que se llama Journeys.
No.
No.
You just indicated the Y, which is also Safe Connections, would be willing to, would charge you $50 per visit.
Dice que ahorita que mencionó el de YMCA, que es viene siendo la de Safe Connections, que si ellos le cobraban $50 por visita.
No, nada más era una hora. Y pues yo con tal de ver a los niños, yo acepté. En sí le dije, ¿por qué una hora? Si son 4. Dijo, no podemos, la agencia es una hora.
The agency said it was $50 for 1 hour of visit. She mentions that I have 4 hours. The agency said we can only offer 1 hour.
So you would lose time by going to Safe Connections?
¿Perdería tiempo entonces yendo con Safe Connections?
Sí.
Yes.
Did you discuss with Safe Connections what sort of activities you could engage in with the children there?
Preguntó a Safe Connections qué tipo de actividades podría hacer con los niños estando con ellos.
No.
No.
Do you have any third party who would be willing to supervise that you would not have to pay?
¿Usted tiene alguna persona aparte que no tendría que pagar que podría ser voluntaria para supervisar?
En este momento, pues no sé, porque estás hablando de 4 horas. Mucha gente pues tiene su familia y pues Jenny estaba haciendo buen trabajo.
Not at this moment. We're talking about 4 hours. People have their families that they need to attend. Janet was doing a very good job.
Do you believe it is in the best interest of the children to have a relationship with you?
¿Usted piensa que es en la mejor interés de los niños tener una relación con usted?
Claro que sí, ellos vivieron toda la vida conmigo desde bebés.
Yes, I do believe so. They've been with me their entire life since they were babies.
I have nothing further, Your Honor.
No tengo ninguna otra pregunta.
Ms. Dawes?
Thank you. Ma'am, it looks like sometime during the last reporting period, your phone was disconnected and you've changed your phone number. Is that correct?
Dice que durante las últimas visitas parece que usted cambió de número de teléfono o estuvo desconectado su teléfono.
No, yo cambié, pero yo le dejé saber a ellas, yo le mandé un texto que había cambiado mi número.
No, not disconnected. Yes, changed my number. I did let Sherry know that I changed my number.
How many times did you call the police since March?
¿Cuántas veces llamó a la policía desde marzo?
Enero, febrero, marzo. Fue cuando me está haciendo la pregunta, cuando fue que Janet estaba en supervisión.
Are you asking me since Janet was in supervision?
I'm asking you, since we were in court last time, how many times did you call the police regarding issues about Sherry?
Desde la última vez que estuvieron en la corte, ¿cuántas veces llamó la policía sobre problemas con Sherry?
Pues no sé exactamente decirles porque hay varios reportes y yo los fui a recoger a la policía.
She's not absolutely sure. There's several reports and she did go get the reports from the police.
How about Children's Protective Services? Do you know about how many times you've called them since March regarding Sherry and the children?
¿Qué tal la protección de niños? ¿Sabe cuántas veces le llamó a ellos desde marzo que última vez estuvieron aquí en corte?
¿Quién le llamó, ella o yo?
Who called her or me?
I thought the question was, how many times have you called CPS
La
since we were
pregunta fue
last
cuántas
here?
veces usted llamó a CPS desde que estuvieron aquí en la corte.
No, fueron 2 veces.
Only 2 times.
And do you admit that Ms. Vargas took the children without you present in person to Chuck E. Cheese on one of those visits?
¿Y usted acepta que la señora Vargas se llevó a los niños sin que usted estuviera presente al Chuck E. Cheese?
Claro que sí.
Yes, I do.
Do you believe that that was appropriate?
¿Usted piensa que eso fue apropiado?
Yo pienso que sí, para que los niños se distrajeran.
Yes, I do believe so the kids would get distracted.
Thank you. Nothing further.
Hasta ahí nada más.
Redirect.
Yes, Your Honor. That visit at Chuck E. Cheese,
En el Chuck E. Cheese.
were you present by video for that visit?
La visita del Chuck E. Cheese, ¿usted estuvo presente por video?
Sí,
Yes.
Did you interact with the children during that visit?
¿Tuvo interacción con los niños?
sí,
Yes.
Were you able to watch the children engaging in activities?
¿Pudo ver a los niños participar en actividades?
sí, ellos estaban jugando.
Yes, they were playing.
Did the children talk to you during that visit?
¿Los niños hablaron con usted durante su
Sí.
visita?
Ujú.
Yes.
I have nothing further, Your Honor.
We crossing any of that?
No, thank you.
Thank you. Thank you. You can step down.
Thank you.
Step in, anybody else?
No, Your Honor. At this time, we would rest.
All right. Since this is essentially a status conference, nobody is like the moving party. Frankly, it doesn't really matter to me. Ms. Newhouse, why don't I start with you and have you give whatever summation you'd like to give?
Thank you. First of all, Your Honor, I'd ask that the CASA report be marked as Exhibit 1, and I'd move for the admission of that.
Any objections?
No, sir.
All right, I'll admit that as exhibit 1.
Thank you. Your Honor, it's Ms. Lenartz's position that the children should see their maternal grandmother. A supervised situation was acceptable to her. She tried to facilitate that, and yes, there has been drama continuing. However, as noted in the testimony, the last visit, Ms. Lenartz helped orchestrate on her own so that the children could see her. The CASA, our CASA volunteer has recommended that the children be reassessed at Network 180 and provided psychiatric care and therapy as necessary. And I think that's a good recommendation. My client has no objection to getting the kids reevaluated. It's been a little bit of time, so maybe that should happen now. I think Safe Connections is a wonderful organization. It would only be 1 hour, but maybe we do a review a little bit sooner than we've done here. And if things are going better, maybe we wouldn't need a third party supervising. I think there's always going to be contention between the parties and all of that. But I truly believe that both of the grandmothers love the children and want them to be happy. Maybe each of them have different ideas about how that's going to happen. But my client remains committed to abiding by the court orders. Thank you.
Thank you, Mr. Stefan.
Thank you, Your Honor. I'm in agreement with Ms. Newhouse on this, that it is going to be in the best interest of these children to be reevaluated by Network 180 and to be provided with psychiatric care and therapy as needed. The concern at this point, though, is that my client has lost several months of supervised parenting time because the supervisor was, in her own words, kind of driven off in this matter. Safe Connections is a wonderful facility, but we typically only use that in direct situations of domestic violence threat between parents. It may not be the best facility to handle parenting time of this manner. I would respectfully submit to the court that with two attorneys involved in this, perhaps we can agree on a third party that may be able to provide supervision in still a clinical setting. For example, I do know there is a therapist out of Saranac who will provide 3 to 4 hour supervised parenting time periods, and she may be willing to travel and have those done here. I would have to confirm her availability for that. But there is also Journeys, which can allow for longer periods. It may also help if this is in a somewhat therapeutic setting versus a, for lack of a better way of saying it, a cold room with somebody watching through a two-way mirror. That's not going to facilitate the development of the relationship between my client and the children. Everyone's in agreement that there should be some parenting time here. I would, again, respectfully request if we'd be allowed to come back for a status update in perhaps 90 days and get these parties into that supervised parenting time. Again, at this point, it's going to have to be with a paid professional. I would also respectfully request that the parties be allowed to use the grant that the court has available to offset some of that cost.
Fair enough. Thank you. The court concludes that the relationship and cooperation between Ms. Leonards and Ms. Torero will never be repaired. Any slim hope of that is gone. They will continue to be at war. They will continue to accuse each other of anything that they can conjure up, all to the detriment of these children. What a shame. Two grandparents who put at risk the health and happiness of children because they hate each other so much and because they cannot put that hate aside like adults should, so that these children can have healthy relationships with each grandparent. Based on the testimony today, the court further concludes that it is Ms. Leonards is the reason why we don't have a supervisor in this case. The fact is that Ms. Vargas, based on her testimony, made it clear between a combination of threats, a combination of Ms. Leonards deciding to question every single thing that Ms. Vargas has done, she finally decided it's just not worth it. And again, what a shame. Then the person that I have found to be the most credible witness in every hearing that we've had, and the person who shows the most care and concern for these children, would literally say, I won't do this again without a body cam. You two should be ashamed of yourselves. Ashamed. The court previously ordered that Ms. Torrio was to have grandparenting time. It was to be supervised by Ms. Vargas, who the court believes, again, to have been the one person who was willing to put the children's needs first. The court cannot find that either grandparent is particularly credible. Each is focused on their own agenda and anger, and that's the way it has always been since the beginning of this case. You know, let me remind everyone that there was a time when the Department of Health and Human Services was throwing up their hands about what to do with these two grandparents. One of them was regularly accusing one of these grandparents of threatening and of doing a number of other things. But the department basically said, we don't know what to do with this situation because these two people will never put aside their differences and their hatred for each other to do what is best for the interest of their grandchildren. The court orders that counsel are to seek agreement on a supervisor for Ms. Torres's grandparenting time. It is not to be a supervising agency that requires the grandmother and grandchildren to go to a specific location for a limited period of time. It shall be a supervisor who accompanies Ms. Torres and the children on any activities in which they are engaged during the grandparenting time. And it is also going to be a supervisor who is going to be required to be present at all pickups and all drop-offs, so that then we have hopefully an objective witness as to what's really going on during those times. Ms. Leonardson and Ms. Torero will split the cost of the supervision. The free supervisor was caused to withdraw. We had our chance at a free supervisor. We had our chance at taking advantage of a lady who cares so much about these kids that she was willing to do that despite having a full-time job. Well, we blew that one. Not me, we. I'm talking about both grandparents. Frankly, the court can't trust either of these people. And this inability to put the children's interests first is, again, shameful. Both children will begin with the supervised parenting time. Both counsel shall speak to the supervisor every 2 weeks together and gauge the supervisor's opinion. I am sensitive to what the child has apparently told CASA and others that the daughter or granddaughter, if you will, is not interested in seeing her grandmother, but it's always impossible to determine whether that's the result of poison or not. So I'm ordering that both counsel speak to the supervisor every other week, not just to find out how it's going with respect to the supervised grandparenting time, but also to find out what each child's preference appears to be. If some of the grandchildren or one of the grandchildren or both say that they don't want to see Ms. Torero, then that should be reported to the court, and we'll meet with counsel and I'll make a decision about that. But I didn't read anything suggesting that the boy in this case does not have any interest in seeing his grandmother. I think it was only the girl in this matter. Each child should be reevaluated, by Network 180 for appropriate mental health referrals. I ask that counsel schedule that as quickly as possible. Also, I want counsel to keep the Department of Health and Human Services posted with every development in this case, so that they are also aware of what is going on. We'll come back here in 4 months and we will see where we are. The court remains willing to do anything that the court believes is in the best interest of these children. That could include re-examining whether the guardianship should remain with Ms. Leonard's or whether it should go to the other grandparent or whether it should be both. The court is going to do what these children require, which is to have supervisors, in this case, grandparents, that will put aside their petty differences and work together. If we all recall, the reason why this case ended up in a guardianship is because the children's father was struggling with drugs. I understand he's made great progress, and I'm very happy about that. And because the other parent died, as I recall. You know, I mean, it's not like anybody wanted this situation to happen. Two grandparents who understand that these children permanently lost one parent and at least temporarily lost the other because of drug abuse. He's hardly the only drug abuser in the world. And yet they still just can't seem to figure out. It's not about us. It's about the kids. Anything else to come before the court today?
I have nothing, Your Honor.
Which of you would like to draft the order and run it by the others so it can be entered as quickly as possible? As soon as the order is entered and a supervisor is found, we will begin grandparenting, supervised grandparenting for Ms. Torero. Anything else, Ms. Newhouse?
I was wondering, did the court say, would it be the same 4 hours of?
You know, to be honest, I mean, I didn't address that. I mean, you know, now that I got two lawyers involved, I mean, hopefully you and Mr. Steffen could sort of discuss that with your clients as to whether the same 4-hour block makes sense. I mean, I just don't know enough about, you know, about what's going on the ground at this point.
Okay.
I mean, presumably, well, go ahead, Mr. Steffen.
I was going to say, thank you, Your Honor. It may depend on who we can agree on as a supervisor as well, if they're available on a weekend or only during weekdays.
I mean, I think all of those things are true. I mean, yeah, I was gonna say, I guess I would hope it could happen on a weekend because I think that's probably the best time for actual, a visitation without interruptions, but I can't gauge that. I don't know what the supervisor's schedule and availability is going to be. I got two good lawyers who I think, who I have a great deal of respect for, and I just have a feeling that you folks can work this out. If you can't, you know where to find me. I'm in the business of making decisions. Thank you all. Have a nice weekend.
Thank you, Your Honor.
Thank you.
Your Honor, can I just have a date? for the new
Yeah,
one?
let's give you a date for that next hearing. What is it? February 10,
2023 at 11 a.m.
2023, 11 a.m. I'm permitting counsel and others to generally appear by Zoom, but I must say it's my preference to have everyone here in the courtroom. But I understand people are busy, people have logistical problems, but my preference is that everybody be here. That's not a crack at you, incidentally, Ms. Newhouse. I'm just saying, because these days, after Zoom, we're really trying to get back mostly to live hearings. Now, the Michigan Supreme Court just issued a court rule saying, almost all criminal proceedings are supposed to be live, but then, in civil pre-trials, those are supposed to be by Zoom, but fundamentally it's my discretion. So I'm not ever going to say you can't participate. I think it's important, and especially in a contentious case like this, that everybody be present. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Deb, are you going to email us?
I can. Who will be doing the order? Who will be going into the order?
Kristen, I can go ahead and draft it up and send it over to you.
Okay.
Okay. So do you want me to just give it to you, or do you want me to email it?
Got it. Here.
February 10th.
What time?
11 a.m.
All right.
Thank you.
Thank you, Deb.
You're welcome. You guys have a good weekend. Nice to see
You
you. I
too.
never get to see you anymore.
I know. I wanted to be there in person, believe me, I prefer that too. Didn't want to contaminate you. Did Judge tell you, maybe Kathy tell you I have COVID?
I saw the email. I am sorry to hear that. How are you feeling?
I'm feeling well. I just can't seem to test negative.
Yeah,
You did see your lunch get delivered out your back door there, though. It's probably
What?
getting pulled. Something got delivered right behind you.
A lot of things happen here, yeah. I had a cat at my door for a while too.
perfect. All right,
All
thank
right,
you.
have a good weekend.
All right, thank you.